I cannot sell the property because no plan will be sanctioned. Give your my lord.
Lordship, may I have Lordship's kind leave to mention a matter for withdrawal of the writ petition? Lordship, it will be listed before your Lordship on 24th July, Lordship.
Yes, Mr. Mehta.
My lord, may I be permitted to mention a 70 years old person, my lord, in case has totally, my lord, blocked, my lord. I have filed an application, my lord.
He's involved what?
My lord, for the demolition of that question, my lord.
Give your
Well, extension of interim order. We are protected till today.
yes. Why at the last minute, Mr. Ravani?
My lord, I'm sorry, my lord. I would, my lord, whatever I say, it would just be an attempt at justifying, my lord. It's our fault.
Under compelling circumstances, my lord, I am mentioning. My lord, my parking lot, my lord, is put up for auction by the concerned municipality. My lord, I have been, my lord, in that parking lot, my lord, I was
Having an agreement. When did your agreement expire?
my lord,
You must be running the parking lot in
Yes.
terms of an agreement. When did
My lord,
the agreement expire?
I was seeking for COVID extension for a period of 1 year. Out of 20 parking lots, 19 were given that privilege. I was not given that privilege. My lord, difficulties now, my lord, municipality has put up for auction that parking lot.
That's
So,
fine. What is the difficulty in that? Give your slip.
May I permit to mention?
Otherwise, my lord,
These are all contractual parking lot. You are running it. You don't have a right to run
out
it
of
for.
2019 got the exemption for a period of 1 year because of COVID-19.
Give your slip and see.
May I permit to
Item
mention?
number 2759, my lord.
We'll see that.
Your Lordship, I am Kamal Kumar Chakraborty, age 83. My case number is WPO 598 of 24. It is to be heard only on Thursday, this day. And I am seeing every Thursday, it is instead of progressing, it is regressing. That is, it has come now listed at 115. And I am not sure if I could see the end before I expire. So my appeal or a prayer is to you that kindly fix it for a day so that I can see the end of my case.
You will see the end of your case. Don't worry, sir.
May I permit to mention for arbitration original side matter, Lordship, the matter is that the petitioner who has rendered his service for more than 27 years, he has not received any single promotion till date. Because of the new advancement, merit cum seniority basis for that, and he has not giving any promotion till date. Lordship, kindly take the matter on an urgent basis because he is retiring soon on 2028. Unless it is
Which post is he working on, madam? Right. Give your slip, please.
grateful, Lordship.
Sir, it is on serial number 115 today. Can it be hard?
It can't be heard today, sir. We'll see.
You fix it for a day, sir.
We will see, sir.
Lordship, may I be permitted to mention one matter for arbitration? Lord, I am
Hey, Manoj. Manoj.
My lord.
My lord, may I beg one indulgence? My lord, I have mentioned thrice. My lord just made an observation, Mr. Sengupta, come some other day. My lord, for the last 1 month. My lord, that is in touching hearing matter, everything is complete. The matter was heard thrice before the Honorable Justice, my lord, some other bench, when the Honorable Justice was taking up that determination. My lord, the problem is, my lord, that everything is
Slip, sir.
100, my lord, I have handed over the slip and
It will come in due course. Sir.
yes, my lord.
It will come in due course. It will come in.
It will no, already it is in the list, my lord.
It will come in due course whenever it has to come. It will
My lord,
come.
only thing, my lord, the difficulty is, my lord, subject to my lord's again approval, my lord. The matter was heard thrice before the Honorable Justice, my lord. And my lord is about to, my lord, I have to hand over the or submit the, my lord, the written notes of argument. My lord, in this, at this juncture, my lord, kindly consider.
If the matter was part heard,
No, matter was not part what. That's why.
what can I do, sir? If the matter was not part heard.
My lord, only thing because the rainy season, my lord, the building already chunk of portion of the building has already collapsed, my lord.
You'll see.
My lord, now, my lord, see, my lord, it is not habitable. Now only the tagging, my lord, no demolition, nothing of the sort. I cannot reside there. I have to take a rent. I have already took the rent.
Give your slip, we'll see that. Sir.
My lord, kindly, my lord. I have mentioned, my lord, thrice, my lord, my lord was
That
kind
doesn't-
enough to make an observation, Mr. Sengupta, to come, try on next occasion. My lord,
I will again say the same thing. Mr. Sengupta, please try
my lord,
come next.
my lord, only thing, my lord, I am praying, I am begging. My lord, kindly fix any date.
Give you a slip, Mr. Sengupta.
Yes,
Where,
I have already mentioned 10.
where is your slip?
Sleep on the last
Where
occasion.
is your slip, Mr. Sengupta, today? Where is your
No,
slip?
today is no, I am not.
Then sorry,
My lord, it
sorry.
is the unauthorized construction.
Follow the norms of the court, Mr. Sengupta. Things don't change for you.
No, I am not.
Things don't
I am
change
not.
for
I am
anybody.
not. I am not the person like
Okay.
that I am.
So if you have a slip, give it. If
But
you
then,
don't
my lord,
have,
I will mention on
mention
tomorrow.
it next time.
Yes, yes, sir.
My lord,
I will mention.
on 24th, your lordships call the matter. Due to my illness, I am not appearing. Your lordships adjourn 8 weeks. But the unauthorized construction by a local club.
Very
My lord, that's why I praying before your lordship some preference.
You should have come.
Yes.
That's your problem if you have not come, sir.
My lord,
These are not matters. Let the construction come up, it will get demolished.
Your
All
Lordship-
unauthorized construction will get
Your
demolished.
Lordship, may I be permitted
they
to mention a
complete-
matter?
They, in the meantime, they complete this. That's why I
That's
pray.
very good, sir. Let them spend some more money on the construction. Anything which is illegal will go. You should have been here when the matter was called out. Whose fault is it?
My lord, kindly give some
No, no,
preference.
sir, sorry.
Your Lordship, may I have your leave to
Yes,
mention a matter?
Yes.
Your Lordship, this matter was mentioned thrice before your honorable
Very
court, Your
good.
Lordship. Before the summer vacation, also Your Lordship allowed this matter. The mention was allowed by Your Lordship. However, Your Lordship, the matter is not enlisted in the list, Your Lordship.
Mentions are not allowed. Give your slip. We'll see that.
May I allow to mention?
Yes.
My matter is pending for the last 1 year.
Sir, give your slip. We'll see.
4 judicial orders have been disobeyed. The police, in nexus with the opposite parties, have completed. You were also, when during Justice Bakshi's period, your order also has been violated. And the KMC has confirmed in the written statement that illegal construction has been done. Even after that, the 4 judicial orders have been violated. I seek, because today is on 112, is it possible that I can be heard?
I don't know, sir. That depends on the board. That depends on the matters. How can I tell you whether 112 will reach or not reach?
It's my prayer before you, Your Lordship.
We will see, sir. Give your slip. We'll see that.
It's my slip here.
My lord, may I allow to mention before your lordship an appellate side matter? But for correction, the double pension matter, the disabled son and unmarried daughter matter, my lord have passed the order. There are some correction, my lord, the date of death and my lord, the deceased,
Make the correction. Give it to him.
and my lord, one thing, my lord, there are some, my lord has recorded that the disabled son is receiving both the pension, but the disabled son receiving only the female employee's pension.
The disabled son.
Disabled son.
He is receiving mothers and fathers both.
Mother's, no, not only the mother's pension.
Just make the correction.
Lordship, may I be permitted to mention a matter for upgradation, which is
Give your
running as
slip. Give
item?
your slip. For upgradation. Give your slip.
My lord, may I permit to mention one matter for correction, my lord. We are appeared on the order date 26 June 2025, but our name not in the apparent list, my lord.
Yes.
Last Thursday, my lord, I have mentioned the matter with the orders and no information.
Give your slip, madam.
I appeared for the private response. My name is not appeared.
Your name is not there. Give your slip.
My junior mention. Boro slip দিয়ে mention করেছি।
Hey, where's the slip? Give a proper slip.
Sir, proper slip দিয়ে দিয়েছি। Sir, proper slip.
Give a proper slip.
We are facing a problem. I just indicate, my lord, what the problem is. Well, this is that restoration. My lord did not take the trouble to look at the records today. Restoration application at the of my lord a writ petition at the instance of one of the writ petitioners. My lord,
You were saying others are also joining.
yes. Now, my lord, the difficulty is, my lord, the client has come. One of the other writ petitioners has come. My lord, the Vakalatnama is ready. Application is ready. My lord, by way of amendment caution, a section 5 application, though that is not required, my lord, is also made ready. My lord, the erstwhile learned advocate, my lord, it's very embarrassing for me, my lord, to say this. He is not giving, my lord, his consent, my lord, is no objection. My lord, I have requested, my lord, my learned advocate on record, my lord, to issue a letter. My lord, I was jokingly, my lord, saying to my lord, learned friend on the other side, whether, my lord, they are holding his hands or not. Milord, I will just, Milord, issue a letter. If something happens. If it does not happen, Milord, will come, Milord, on the returnable day and do the matter. Milord, I'm sorry, Milord, I'm troubling my learned senior friend every day. I'm apologetic to him. But Milord, this is the difficulty that I am facing.
He's happy.
So, I mean, we are waiting to respond.
He's happy to be troubled. When is the date? When is it
Milord,
fixed? Is there any date on
Return,
this?
Milord, 1 week after, Milord, subject to my lord's kind, Milord, convenience.
At the request
2
of the
weeks, Milord, may it be after a fortnight, Milord, as my lord.
Let it be after 14, only one prayer as a last chance. If your lordship mentions, that will help his clients buckle up.
At the request of the learned counsel petitioner, let this matter be listed after 2 weeks.
2 weeks.
Not recording.
Grateful to your lordship.
Or my lord, I appear for the petitioner. My lord, here, my lord, I'm being led by Mr. Rajoshi Dotto. My lord, he has some personal difficulty. He hasn't come to court today. If my lord will kindly adjourn it for a week only, my lord. Only for a week. There was a direction upon us to file an affidavit or rather an exception to the report filed by the KMC. We prepared that, but my lord, my leader is in some personal difficulty today.
Proxy counsel so and so appears and states that the main arguing counsel,
Mr. Rajoshi Dotto has some personal difficulty today, my lord. Mr. Rajoshi Dotto.
Mr. Arushi Dotto.
My lord, the affidavits pursuant to my lord's last direction may be kept on record, my lord, subject
Is
to my
it
lord's.
disposed? Let this matter be listed after 2 weeks. After 2 weeks.
My lord, may the affidavits be kept on record, my lord. My lord had directed me to file an exception to the report. May that be kept on record, my lord. My lord, there's an exception as well as an affidavit of service, my lord. Of these.
Affidavit of service is taken on record. Exception to the report is also taken on record.
Obliged. Deeply obliged.
Next week. Well, matter will be taken up next week, my lord.
After 2 weeks.
I am for the petitioner, your lordship.
Next week.
My lord, I am for the petitioner, my lord. It's the unauthorized matter is in connection with the unauthorized construction, your lordship. Kindly come to the page 12 of my petition. Is admittedly there is unauthorized construction, my lord, 415 square meter. Page 12. Page 12 is admittedly, my lord. Page 12 under the chart, my lord. Area of total unauthorized construction 415 square meter. Then your lordship, kindly see the last order passed by your lordship on 24th April 2025, passed by your lordship. I am pressing that order.
Distribution 26th April or
24th April 2025, passed by your lordship. May I read that order, your lordship?
No.
May I read? The last paragraph is very important, my lord. The commissioner is liberty to carry out the orders.
Yes, what has happened after?
My lord, on that date, my lord, there was no stay, my lord. Now, then your lordship, what's happened, your lordship? May I hand off the copy of the order, stay order? The tribunal, my lord, the building tribunal passed the stay order, ignoring your lordship's order. Kindly see the order.
Madam, they are allowed to pass any order. My order is only to the extent that if there is no stay, they have to carry on.
Hey, but on that date, my lord passed the order. No, my lord passed the order on 24th April. And the corporation passed the order 30th April, immediate thereafter, ignoring your lordship's order. My lord, kindly see
my order, madam, please.
that was not mentioned. There is no whisper as regard your lordship's order in this. This order is not reflecting.
I have gone to the tribunal at liberty to file pass any order.
But my lord, when the my lord passed the order, kindly appreciate there is no.
Madam, please, I know what order I have passed. Don't tell me what order I have passed.
Well, 2010 and moving pillar to post, my lord, only for demolition of unauthorized construction.
Madam, if there is a stay and the matter is seized by the building tribunal, they will look into it.
Stay passed after passing your lawsuits.
That's all right, madam. I have not given any comment on the merit of the matter. Please. Who appears for the corporation? Yes.
There is an order from the tribunal, therefore, my lord, we could not demolish them.
Yes, yes. Go and contest before the tribunal.
My lord, my lord's order was not placed before the tribunal, your lordship.
Please. I know what order I have passed.
Then, my lord, time should be framed. Otherwise, they will linger the matter.
I'm not here to govern other people's board.
But kindly,
I'm disposing of the writ petition. Go before the tribunal.
but with the direction of time frame order should be passed, your lordship. Otherwise, they will delay the matter.
Whatever it is, madam. I'm not dictating other people's board.
Kindly request them to hear the matter within 4 weeks.
They will hear it whenever their board permits. Take down. The petitioner has preferred the present writ petition, seeking a demolition of the alleged unauthorized construction in respect of premises. This is MN80, page 7, para B.
Yes.
What is the description of the premises? Premises number B14. B14 oblique H. B oblique 14.
B oblique 14 oblique H oblique 4.
Bindu Basini Street, Ward number 78, Borough 9. At behest of the private respondent. Full stop. Where's your report, sir?
Report has not yet come with me, my lord.
So you have handed over this. You have handed over the tribunal order.
No, I have not.
Or report is here.
Earlier. আগে দেওয়া ছিল সেটা করে নেই
Had preferred the writ petition so and so. A report had been filed by the executive engineer C, building Borough 9, wherein it is stated that the department had issued a work stop notice under section 401 of the KMC Act 1980 and subsequently had passed an order of demolition. Full stop. Order of demolition dated 9/5/2024. The said demolition order was challenged before the Municipal Building Tribunal. The tribunal-wide order dated 30th/4/2025 has stayed the demolition order. Full stop. At this stage, the present issue regarding the unauthorized construction is seized off by the tribunal, and the relief sought by the writ petitioner cannot be granted at this stage, since the matter is pending before the Municipal Building Tribunal, Calcutta Municipal Corporation. Full stop. What do you want? You want to wait?
My lord, kindly frame the time, otherwise they will.
Ma'am, I'm not framing any time. Do you want to go before the tribunal or I dismiss it like this?
No, I want to move there.
Learned counsel for the petitioner at this stage
Otherwise,
states that she would
but as early as possible, my lord.
remedies before the learned tribunal and does not wish to press the present writ petition at this stage. She seeks to withdraw the present writ petition. The same is dismissed as withdrawn. In view of the above development, she wishes to withdraw the present writ petition. The same is dismissed as withdrawn. Yes.
Lord, Nico House is a important building, Lord, in central Calcutta. It's an office building.
Yes.
I own structures on the 7th floor of the building.
Yes.
Some person, Lord, who had taken possession of a part of the building made complaints that a portion of it was allegedly unauthorized. This has been standing for years. Now, my lord, a proceeding was initiated by the Kolkata Municipal Corporation under 400 subsection 1. Everyone was given notice. Everyone was being heard. The proceeding is still pending. There has been a direction for a structural stability certificate to be prepared so that the stability of the building can be looked into, and plans are being searched out by the corporation from their own records. Because up to now, the complainant says that there is only a plan up to the 4th floor. But there are sanction plans otherwise also. They are being searched. Most of them, my lord, are old plans. They are being searched. In the midst of this, and it is continuing, suddenly by an interim order, my 7th floor has been told to be demolished. And the corporation authorities, my lord, came up to demolish my 7th floor. My lord, this is the order, my lord, which I have challenged before your lordship. My lord, kindly have a look, my lord, at...
But the issue is regarding whether they had served a notice upon you or not, right?
The issue is regarding whether in the midst of the proceeding, where everyone else is being heard along with me, and the proceeding has not come to a conclusion. Fact-finding exercises are still underway. In the midst of this, without giving me any notice, we come in, an order of demolition is made qua the 7th floor.
No, you have not. That's
Yes,
you have not been
yes,
given.
I have not been.
That is your main contention.
That is my main contention.
Yes. But tell me, since you are appearing, Mr. Banerjee.
Appealable. Appealable. We had to rush because they had come to demolish.
Yes.
If your lordship, lord, permits us, we can file an appeal. If your lordship not extends the order of stay for a limited period, we can go and file an appeal.
I can give you time for 2 weeks.
Only I'm submitting, my lord, to that, my lord, that his right to prepare an appeal should be kept open for decision by the learned tribunal.
Everything will be left open.
That is I'm submitting, my lord.
Then he takes up this point here.
Including his right to prepare an appeal.
If I invoke an alternative remedy and that alternative remedy is not made efficacious by the respondents raising technical points, they can raise it here so that it's decided.
Because the law has been decided, that is I'm submitting. He can argue the point before the learned tribunal.
Let this issue be decided. Let this issue be decided here. Otherwise, my alternative remedy becomes meaningless. If I go to the tribunal, he takes that point.
If you are raising the issue of maintainability,
In the sense, my lord, because he has himself said that he is a purchaser of the structure, but he is not the person responsible for making that another construction. Therefore, it has been decided by the court that the person who has no connection with the construction, he is not to be heard. The person who has caused the another construction, he has been given the notice and he has been heard.
Let us decide this.
Yes.
Then we also decided, because my lord, this is the main issue, where otherwise 16,000 square feet has been erected without obtaining any permission. 16,000 square feet
perhaps not
on the roof. That is there. Structure is there. It's not a minor construction. I could have
Prima facie, I am of the view, Mr. Ghosh, that maybe he has purchased the property subsequently. You had issued the notice to the builder concerned, and then the demolition order had been passed. Subsequently, he has purchased, or in between the proceedings, he
I
has
purchased it
purchased
from a court sale,
My lord.
from an
the auction.
insolvency sale in auction.
in auction. But that will not disentitle anybody to
My
be
lord,
heard.
my lord,
Understandly, you
my lord, I will not submit my lord, anything my lord, to your lordship because this is my lord, the interpretation of law given by the court.
Yes,
Therefore,
that's
your
what I
lordship
want to
consider, your lordship consider those judgments, my lord.
I mean, that's what I want to.
Naturally, your lordship, definitely, my lord, because it is not my lord, necessary for me to, because that which
Correct.
has
I
been,
just want to see what are the precedents in this.
which has been,
The
my lord,
persons who are being heard as of now are also purchasers in possession,
Not the promoters.
not the promoters.
Let us see that.
Yes,
You know,
yes, my
because
lord,
if he's raising, if you are raising this,
if he's raising this, my lord, then he
naturally,
decides it.
because my lord, otherwise, my lord, if what my lord is observing and what my lord is saying, because his argument in different case would be on a different way. Therefore, my lord, I want to submit to your lordship, my lord, what is the law is there, at least to be placed before the bench, my lord, bench to consider, my lord, what way it is to be done.
My lord, I am ready, but would your lordship permit me to come back next week and come back with the entire array of judgments? I can satisfy your lordship.
come up with the judgments, we will decide this issue of
Yes, of maintainability.
maintainability.
Otherwise, my lord, sending me there will be meaningless.
At the request of the learned counsel for the petition, let this matter be listed next week.
Next week. There's an interim order till today.
I also want assistance.
Yes, yes.
Come prepared.
Yes, I'll come.
Because this issue is coming in most of the matters.
And my lord,
And
both
we
ways, I
asked-
requesting my lord, my lord, both ways argue in his favor and also against my lord,
Why
both
not?
my lord, be placed before the court,
Why not?
so that court may, my lord, be appraised, my lord, all the law, my lord, has
This
decided.
point was earlier taken up, my lord, for consideration by my lord, an honorable single judge, also by an honorable division bench. We at the bar failed, your lordships. We did not ask the proper question and therefore did not come at the proper answer. I'll show you, lordship. Natural justice has nothing to do with right. It has only to do with adverse civil consequence. If anyone has an adverse civil, if I am a person sitting on the pavement, but sitting for a while, even I have the right to be heard before I am removed. Not that I gain any right out of that hearing, but I have a right to be heard.
That's my prima facie.
That's civil consequence. We argued, and my lord, we have failed, your lordships, lord. We argued on whether someone has a right to immovable property if it is unauthorized, and therefore why should he be heard, etc. We were, I think, my lord, completely addressing a different question. Natural justice is not concerned with the right. Olga Tellis has made it clear, it's not concerned with the right. You may be having no right over property, settle possession. If you suffer an adverse civil consequence, someone takes you out of possession, that's good enough for you to be given a prior opportunity. So we'll address your lordship note on that. I don't think there'll be any.
He is also getting a hearing also before this court.
Yes.
Regarding your right, for the making of construction
He's
or
saying that
possession of
because I am a
things out there.
petitioner and the court is hearing me, that itself shows that there is natural justice.
No,
I support it.
I'm submitting my lord, regarding that all of the making of unauthorized construction, that part. This is the
It's
main
not
issue.
unauthorized. It's not unauthorized.
He has, Mr. Govash,
My lord.
he has not made the unauthorized construction.
No, he has not made.
Unauthorized construction
He has
is
the
being
he has
done by the
he is the
builder.
purchaser of unauthorized construction.
There's a company.
He is the
who has
purchaser of
made it.
unauthorized construction. He can get a right because of somebody purchasing, that cannot automatically give the unauthorized construction the authorized one.
True, true.
That is the issue.
But the question is whether I
Whether,
can,
my lord,
whether
because
I
see,
can.
nowadays, your lordship knows, my lord, that in a mushroom manner, my lord, the unauthorized construction is being
not
constructed. And my lord, everyone is, my lord, immediately purchasing a price, and they are starting business or something before you take an action. And then everyone, my lord, comes, then it will be very difficult, my lord,
So
for the court and also us.
won't he get the right to challenge the order of demolition before the
Yes, tribunal, yes. He's a person aggrieved.
That is to be considered by lordship.
He's affected, whatever
I'm
it is.
affected.
Today, he is affected by the demolition order.
My lord.
He is in possession of the property, rightly, wrongly, he has purchased the property. You can come up with defenses that, he should have known, there were proceedings pending. Maybe it was not informed to him. He's auction purchaser. He doesn't know anything about the property.
I've got it
Shouldn't he
in
be
IBC.
heard? That is not stopping the demolition order. But doesn't he have a right to be heard?
But my, at the same time, lordship, my lord, knows, my lord, it is well that when a purchaser will purchase the property, he must be aware of
He should have
everything.
done all the due diligence.
He must be, my lord, aware of them. He must
Then
have
you come-
first of all
you come
inquire,
up-
my
you
lord,
come
whether
up-
the property is, my lord, the
Mr.
authorized
Ghosh,
property
you
or
come
not.
up with a judgment as is where is basis.
My lord.
All right. There's a
Last one of
Mr.
Justice
Mukherjee has just enlightened me with that judgment.
Justice Chandrachud. The last one is Justice Chandrachud.
Division bench of this court. And yes, and Supreme Court.
Supreme Court. Justice Chandrachud. Justice
Yes,
Chandrachud's
yes.
one was the last one on as is where is. a 3 judges bench.
Yes.
And we had occasion, my lord, to argue that ad nauseum, and the judgment has been reserved. So
There's one judgment which has already been pronounced.
yes, KC Ninan, and another judgment. Yes, constructive notice. But still, then the question would be natural justice. I forgot to pose. In fact, I went back home when I was at the drawing board. I cursed myself for not posing the right question. Right question was, what adverse civil consequence do you suffer? It's nothing to do with your right. You may be the worst possible right holder in respect of a property. If you suffer an adverse civil consequence, as in you're in possession, you're dispossessed, something which you are entitled to do or you were doing this far, you cannot do anymore. That's an adverse civil consequence. The moment that happens, the natural justice gushes in, my lord, because it's a general principle, it's a fundamental principle, it creeps into every statute.
State jacket formula also.
No, there is no state jacket
formula. That every situation, every interpretation of law, the one has to be heard.
Whether at the entry level I can be sent out.
Next week.
Yes. Next. No, there's an interim order, my lord. Kindly extend it for a very short period.
Already continuing to.
Interim order is still today.
Till today?
Yes.
The interim order granted earlier by order dated so-and-so decline order is extended further for a period of 2 weeks.
Obliged.
Or until further order, whichever is early.
Obliged.
Yes. At the outset, Mr. Kara, my office has informed me that I have also made an application for the membership. It has not come through. It is not there, but I have made an application. I should be candid to.
But I don't think that.
There's no, I don't think.
Subject to your.
Yes, I have not absolutely no.
I'm still not a member, but
no,
the
absolutely
application is pending.
But I'm a member.
Yes, in fact, Mr. Kaur should be stop from arguing anything to the.
On my part, I should.
Kindly, this relates to it's a private club, private membership club.
Yes.
Whether it can be treated as a public premises, and whether amusement tax can be levied. For all this while, there's been no amusement tax. There was an earlier round of proceeding where there was an interim order, then the writ petition, we were not aware, writ petition got dismissed. But this is a fresh cause of action, which is a reason where they made a demand and they've gone also and pasted a notice in the club itself. Now, if looks at section 422, and we have some authorities on this as well, which I want to place before my lord. Kindly look at section 422 of the Kolkata Municipal Corporation Act. Amusement tax, they have a schedule where on the basis of which they
updated. Mr.
Charge.
They had given me this. 422.
422, my lord. ঠিক আছে ঘুরে এসো রাহুল আছে তো এখন হয়ে যাবে আর আসবে না
Yes, Mr. Bandri.
No person, let's see, first the heading is theaters, circuses, exhibitions and places of public amusement not to be established without permission. So this is only the heading, that doesn't, but I'm just showing what no person shall, without the written permission of the municipal corporation commissioner or otherwise, than in conformity with the conditions, if any, of such permission, which shall be granted subject to the provision under section 425, use or permit to be used, or materially alter, enlarge or extend the use of any premises for the purpose of establishing or keeping open any theatre, cinema house, drive-in theatre or cinema house, circus, fair, fete, exhibition or dancing hall, or any other place of similar public resort, recreation or amusement for any such purpose. So, if you use the blue pencil theory, so to say, use, if we come back, use or permit to be used. So, which shall be granted, use or permit to be used or materially alter such any premises for the purpose of establishing or keeping open, and then public resort, recreation or amusement for any such purpose. And provided that nothing in this section shall apply to private performances any place. Then the municipal commissioner may specify any provision. So, my lord, the question is, my lord, whether, my lord, the private membership club, where, my lord, entry, my lord, is restricted to, my lord, members and their guests, whether that can be considered as a place of public amusement.
Today your junior is not here.
My lord, he was here, my lord, he's gone to make, my lord.
I mean, it was on Mr. Carr's statement. We had put a query to him.
Yes.
See, as far as this is concerned, the proviso, it is very clear. It is your performance, a member's performance, there is no problem. But when you are renting it out or you are holding.
Member.
Not member.
Member.
There were ads.
Yes. My lord, the advertisement, my lord, is by the sponsor. My lord, there are two documents which were handed over. First, my lord, was a document where, my lord, someone has.
I'm a member.
Yes.
All right. I'm using it for purposes of holding some concert. I'm charging for it. Now, this is not by no stretch of imagination can this go within the definition of my performance.
No, my lord, members don't rent it out, my lord, for program. No, I'll tell, my lord, two things, my lord, which was handed over.
Yes.
First, my lord, first show the other one. My lord, first is, my lord, a venue look. We have written to them. This is, my lord, what was handed over. I don't know, my lord, whether that. No, that is one. I'll come to banyan tree immediately when there's one venue look. My lord, they list. My lord, this venue look, my lord, is an independent, my lord, third party, my lord, website which lists places, my lord, in Calcutta. In fact, my lord, I found that, my lord, it is also listed, my lord, other clubs also, including, my lord, Bengal Club and everyone, where, my lord, they say there's a venue. That doesn't mean anything because they, my lord, and we have also immediately, my lord, written to them, my lord, saying that you cannot list because this is only for members and when they book for their guests. Otherwise, no. And, my lord, immediately, my lord, we have written a copy down. Other side, copy down. After, my lord, we came to know because we were not aware. My lord, I'll give a copy to my learned friend as well. Yes. So far as venue look is concerned. Immediately we did, my lord, what they do, they list out, my lord, all these places. I mean, quite naturally, my lord, to promote their possibly, my lord, web use. But that doesn't mean, my lord, anyone, my lord, at the members of the public, my lord, can come and, my lord, make a booking or have an event.
Yes.
Even, my lord, private members can't, my lord, have an event in that sense. They can rent a hall and, my lord, have their own private event.
Yes.
And whoever comes, my lord, will be guests of that member. Today, my lord, knows, my lord, it is given out, my lord, for marriages.
Yes.
So that's a private event because a member is booked and, my lord, only his guest or her guest, my lord, is really allowed.
Yes.
Senior parties.
Correct.
Senior designation parties.
Yes. Senior designation parties and, my lord, seniors, juniors, events also, my lord.
Yes.
We have been, so, my lord, that's one. Two, my lord, so far as this is concerned, this, my lord, I also, my lord, the banyan tree. My lord, banyan tree, my lord, is a sponsor of one of the events which had happened. It's also, my lord, a club event. Now, my lord, here, first of all, my lord, I do not find, my lord, that, my lord, there's any price, my lord, which is mentioned, my lord, in this. Whether, my lord, banyan tree, my lord, was selling tickets or not, that is, my lord, not sure. Because what happened, my lord, when a sponsor comes in, it is not Toligans Club, my lord, who's given this.
See, Mr. Banerjee, the moment the tickets are available on Book My Show, it means it's being sold.
That's for banyan tree.
Yes.
Not Toligans Club. Because they are sponsors. So, my lord, as sponsors, my lord, we'll have to give them, my lord, either, my lord, 20 tickets, 30 tickets, depending on the event. Or 300 or 400 tickets. So, we do not know, my lord, there's no, my lord, understanding with us to say, my lord, they can sell. Or, my lord, they're selling. Because bookmyshow.com, banyan tree, my lord, has gone. It's not, my lord, Toligans Club, my lord, who's gone to the public and said that. Because this is, after all, my lord, a club event where we have a sponsor. And then, my lord, most of the clubs, my lord, will find, my lord, it's not possible, my lord, for these big programs which we get, my lord, for our members to do it, my lord, without sponsors. We have, my lord, IndusInd Bank or, my lord, anyone else, my lord, always, my lord, sponsoring these events. Now, they also, my lord, sometimes if it's, my lord, at a smaller level, they might say, give us 10 seats. It's not tickets, it's 10 seats. So we would then give them 20 or 30 or 40 seats depending on the event, whatever they depending on the sponsorship. But it still continues, and that is important. It still continues to be a private members club and not a public entertainment place. It's not Tollyganj club who's selling tickets to the public. And they can never do that. The articles will prohibit that. Knows all clubs we are now governed by the mutuality clause, and that is why we have the service taxes, the GST, all because it is considered to be a members really contribution and members getting back. And there's also a decision on this. I'm sure has had this related to the Dalhousie Institute and learned single judge of our court relying on other decisions. This related to amusement taxes, because as far as I know, and Mr. Kaur will correct me, I don't think any of the clubs are susceptible or being given amusement. Kindly see, I'll just read a part of it. Start is a private members club obliged to obtain permission from and pay amusement fees under section 422 of the Kolkata Municipal Corporation Act 1980, and whether the premises of a private members club is a place of public amusement within the meaning of section 422 of the Kolkata Municipal Corporation Act 1980, and therefore falls for consideration the present writ petition. The first writ petition is a club registered under the Societies Registration Act. It claims to be a private members club and not open to outsiders, having stringent admission policies. Contends that it is not obliged to obtain permission under 422 of the Kolkata Municipal Corporation Act, and therefore not liable to pay amusement fees under such action. In support of such contention, Mr. Sadhu for the writ petitioner relies upon then 1971 SSC, that's the Joint Commissioner Tax, then Commissioner Darjeeling Club, then Saturday Club, then the last is Bengal Club. Mr. Mitra contends that section 422 of the Kolkata Municipal Corporation Act 1980 contemplates a situation where premises open to the public and is used for recreation, amusement and like purposes. Then the owner of such premises may be obliged to obtain permission under 422 of the Kolkata Municipal Corporation Act 1980 and pay amusement fees for the same. So far as the writ petitioners are concerned, he submits that the premises of the first writ petition is not a public place and therefore does not satisfy the requirements of 422 of the Kolkata Municipal Corporation Act. For the first writ petitioner to apply for and obtain a license under such section, he contends that the first writ petition not liable to pay the amusement fees for the same. Then Mr. Ghosh, appearing such, submits first writ petition a satisfied definition of a resort in the meaning of section 422, relies upon the dictionary meaning of various words. Then this submission is made. On next page, will find public resort. Then 422 is set out. Then kindly see in the middle, section 422 of the Kolkata Municipal Corporation Act. Has it in the middle of the next page. Obliges a person establishing or keeping open any theatre, cinema house, drive-in theatres or cinema house, circus, fair, fete, exhibition or dancing hall in any other place or similar public resort, recreation or amusement for any such purpose to apply for obtain a permission from the municipal corporation. Places enumerated in 422 are places where the public have access. This section 422 empowers the municipal corporation to grant permission for the holding of such recreation, amusement in such place, such public places subject to the conditions that may be laid down by him. The question is whether the first petitioner uses or permits to be used or extends the use of its premises for the purpose of establishing or keeping open any theatre, cinema house, drive-in theatre, cinema house, circus, fair, fete, exhibition or dancing hall, or any other place of similar public recreation or amusement for any such purpose. Provided to subsection 1 of section 422 of the Kolkata Municipal Corporation Act states that nothing in the section shall apply to private performance in any place. The rules and bylaws of the first petition on record. Object of the first petition appears to promote the literary and scientific improvement of members, to foster spirit of goodwill and sociability amongst the members, to provide amusement, to take part in promote sports and games, and to embark upon any activity calculated to benefit the first petition or to advance the welfare of the members of the first petition. 7% membership prescribed by the rules and bylaws of the first petition. Also prescribed right of admission as a member and the procedure of election to membership. First petition allows its members to bring in guests to the club premises. Right of admission of a guest of a member is not unqualified and is reserved to the first petitioner. Also prescribed the same guest should not be introduced first petitioner more than thrice in a calendar month. Materials made available in the records, including rules and bylaws of first petition established. First petition is a private member club with the right of admission to membership of the first petition being restricted. regulate and prescribe. Fact is not denied by the respondents. The introduction and admission of guests of a member to the club premise is also restricted and regulated. Club premises of the first petition, therefore, on the basis of the materials made available on record, could not be set to a public place where any member of the public has the right of entry. Any member of the public could not enter into club premises. Entry into club premises is restricted to its members and the guests as prescribed, restricted and regulated by the rules and bylaws of the first petitioner. Section 422 of the Kolkata Municipal Corporation Act 1982, my reading, applies to a place holding any recreation or amusement for the members of the club. It would apply to the places described therein. Club premises owned by a private members club is not described in Section 422 of the Kolkata Municipal Corporation Act 1980. In fact, the proviso Section 1 of the Kolkata Municipal Corporation Act 1980 provides that nothing in Section 422 would apply to private performance any place. Could a premises belonging to a private members club be considered to be a public place within meaning of Section 422 of the Calcutta Municipal Corporation Act 1980? Facts established that the first petition is not using or permitting it to be used or is extending the use of its premises for the purpose of establishing or keeping open any theatre, cinema house, drive-in theatres or cinema house, circus, fair, fete or exhibition or dancing hall or any other place similar, public resort, recreation or amusement for any such purpose. Then, my lord, Mr. Ghosh's submission, my lord, is recorded. Then East India Hotels, my lord, is considered. My lord, he relies on these judgments. East India Hotels, hotel was running a restaurant. Then Young Men's India Association, Supreme Court has held that the view is prevalent in England. Can you look at this? In Young Men's Indian Association, Supreme Court has held that the view which has prevailed in England with regard to private members club has been accepted and applied in India. It has been accepted private members club could not be made subject to provision licensing act concerning sale because the members are joint owners of all the club property, including exercisable liquor. Members of a private members club are the joint owners of general property and all the goods of the club. Trustees were the agents with respect to the general proprietary property and the goods. Fact that the said position has been taken in England in respect of taxation law is noted. Also notes that in England it has been held that a member of club, although structurally a company, did not carry on trade or business so as to attract corporation profit tax. Then, my lord, Darjeeling Club Limited, my lord, is considered. Then, my lord, next page, Saturday Club in the middle.
So if it is not a public place.
Yes.
And what is reflected from these advertisements or these ads or whatever, is that you're selling tickets.
I'm not selling tickets. The club is not selling tickets.
You're organizing something.
I'm organizing where there's a sponsor.
As a sponsor, if they are selling, see, the judgment here talks about the fact that if it's a public space, public place, then in that scenario, Section 422 is applicable. Or
yes.
If it's a private club where it is restricted to the members, only to the members, then definitely.
Malad, may I just, Malad, I'm so sorry, Malad, I'm so sorry for interrupting. I'm so sorry. Malad, it doesn't, it says public place where, Malad, the following things are happening.
All
where,
right.
Malad?
Theater,
yes.
cinema,
yes.
drive-in theater.
Correct.
All right. Those are enlisted, but if you see the conclusion of this judgment,
yes,
it also talks and it says, if you read the last paragraph.
Yes, one of the writ petitioners contain.
Such activities would attract the proviso of Section 422 of the Calcutta Municipal Corporation Act 1990 and therefore be exempt from the changing provision of such section. Since it's a private members club, the club premises would remain private for use of the members and their guests.
Correct.
If it is confined to member and their guests, and if it is not being purchased by any random person who's not a member of the guest also, but any person can buy and he has access to your place, to the club, then you are holding an activity which is like a theater.
Malad, let me, Malad, put it this way. Malad, suppose, Malad, I, as a member, sell tickets. Possible. Club won't be responsible. If the club finds out, club will ensure, Malad, my membership is gone.
According to your bylaws, I don't think so that any members can sell tickets.
They cannot. So that's what I'm saying. So, Malad, it's not that, Malad, the club or its members are selling tickets. Malad, there's a sponsor who has come in. Then we also do not know, Malad, he's put it, Malad, on the site. We also do not know, Malad, whether he's charging money.
We bring in a sponsor.
No, Malad, very important.
We bring in the sponsor for our own entertainment, sir. We are not bringing in a sponsor for entertainment of public at large.
We are not. For the private, for members.
Private purpose.
Correct.
To that extent, I understand we can have an argument here that if it is only being brought for the purposes of me, who's a member.
Yes, correct.
And my guests who are,
Absolutely.
guests of the members.
Absolutely.
Understood. Maybe this argument would be holding some.
I'm sorry, Mullah, that's perhaps Mullah, I couldn't make it that way. That's the argument. Saying Mullah, that it is the program
But
is
if
for the
we say-
members.
If we say that the sponsor is entitled or is at liberty, or he has the freedom.
I'm sorry, I didn't mean
to sell the tickets to anybody.
No, in fact, Mullah, this doesn't say Mullah selling also. The price is not there. Because we are not aware actually.
We are not aware.
We are not aware.
We are not aware.
We are not aware. Because I don't think Mullah, this is also Mullah question because I don't find Mullah any price Mullah
Book
being
my
used.
show. Book my show has to have a price.
Not we don't know. It doesn't have a price.
Banerjee, that's right. But then the moment you see book my show.
Book my show Mullah is not my forte, but anyway, Mullah.
My forte. All right, I do all my bookings through book my show.
Mullah, someone else Mullah has to do it.
Somebody else does it.
Mullah, I have very efficient Mullah booking system Mullah.
That's such.
Mullah.
When we are on the other side, we have juniors. When we come here, we do all our work by ourselves. So we book our tickets.
So I also have other juniors who will do it also. Not necessarily from other states. No, so Mullah is correct. This program is for the members and their guests if they're getting any guests. So it is not really being used as the municipal corporation would like us to accept saying that it is not keeping open any theatres, cinema house, drive-in theatres or cinema house, circus, fair, exhibition, dancing, or any other place of similar public resort, recreation, amusement for any such purpose. Nothing in the section apply to private performance any place. So this private performance is for the members who are there. So entry is not unrestricted.
That's what I wanted to.
So I think this is subject to what my learned friend says. I don't think there was any appeal which was preferred from this judgment. I'm not sure but then we checked.
Any other judgment?
No, that's I think that covers. So my submission is amusement tax is something which is not applicable so far as this private members club is concerned. The documents are there. I'm not showing you, but this is really a question of law. Because they have gone and said at page 41. I'm sorry.
Page 41.
Finish that. This is the notice which was put which has been the immediate cause of action. Page 40 there's a demand. And this is an important question because actually this will affect everyone. All clubs in Kolkata will get affected.
All the clubs.
So the very basic concept what we have understood that mutuality and the club are private premises will get diluted with this stand being taken.
Yes.
I'm so grateful.
Yeah,
I must just take my lord's leave for 5 minutes. Just 5 minutes.
Lord, your lordships have seen the section.
Yes.
Lord, if the performances are a private performances, then Lord, it's outside the scope of section 420. If I host a party in my house and I invite my guests, Lord, there can't be any amusement tax. Because, Lord, the basic concept of an amusement is also, Lord, connected to a gain or a profit.
Yes.
Now, Lord, if a member of a club is hosting a party, he's inviting his guests, Lord, I don't join issue there. It's not, Lord, the case of the Kolkata Municipal Corporation that if the members, Lord, are hosting a party or members are entertaining people or they are booking a venue for the purpose of their son's marriage or daughter's marriage,
correct,
that will attract amusement tax. That's not the case.
That's what I was also saying.
That's not the case. If your lordships kindly, my lord, sees this advertisement once again. Lord, this banyan tree is an event manager. Now, my lord, what is it saying? It says, Kolkata, get ready to experience the Mystic Music Festival of the year. Now, my lord, if it is a members, Lord, a members, Lord, organized a musical
Yes.
festival, why should Kolkata get ready? There's no way, my lord, Kolkata should get ready. Number one. Number two, it says TCS Ruhaniyat is back in your city at Tollygunge Club, Kolkata, on such and such. Book your tickets now.
Yes.
Now, Lord, my learned friend says the sponsorer some tickets. Lord, it does not say restricted tickets. They are saying that book your tickets now with without any restriction, and without pointing out that it is only available to the members. So, Lord, this is an invitation to the public in general to attend, Lord, a function at the club. Now, Lord, there are many such advertisements which we have collected over a course of time. I want to file an affidavit, Lord, to bring on record these issues.
Yes.
Lord, the only issue would be that even in this case, whether, Lord, it would be constitute to be a private, Lord, organized party or privately organized performance.
Yes.
This is the list that we are trying to raise before your lordship. And Lord, today, Lord, the claim is only 8 lakhs and something. It's not much.
Not.
Only issue is, Lord, whether, Lord, these functions or these, Lord, performances.
Issue is whether the clubs can hold these kind of
performances. And Lord, if they do,
yes, then they are liable to, because that will come in the under the
they should, Lord, they should obtain the license in terms of section 425, because 425 is the provision for grant of license. It's not much, but Lord, it's to keep a control. Kindly, Lord, see 425.
Yes.
Condition for grant of permission. In the case of any premises for the use of which a license or permission is required from the government or any statutory body under any law for the time being in force, the municipal commissioner shall not grant any permission under this act to any person until such person produces before the municipal commissioner the license or the permission from the government or statutory body, as the case may be, and submits duly authenticated copies thereof to him, provided that in the case where production of a municipal permission is precondition for the grant of license or permission under any other law for the time being in force, municipal commissioner may grant a provisional permission which shall become final upon production of a license or permission under the said law, provided for that such permission shall be validity only for the shall have validity only for the purpose of fulfilling any precondition for the license, etc. Then it says, notwithstanding anything contained in this act, the municipal commissioner may, while granting permission under this chapter, specify such special conditions, etc. So, Lord, they have to obtain the license. The purpose of this license is to have, Lord, a full control over the situation. Assuming, Lord, there is a law and order problem, or, Lord, any other problem. Lord, this aspect of the matter has been dealt with by the Supreme Court in the...
But, Mr. Kar, if you see, in the case of any premises for the use of which a license or permission is required from government or any statutory body under any law for the time being in force. Now, we have to see this is a precondition.
No, Lord, kindly come to 422. 422, if we get over the proviso, then, Lord, these, if your lordship holds that it comes under the first part of 422, then, Lord, the question of obtaining a license would arise. And based on the license, Lord, the amusement tax. They are not two different, Lord, fees charged. Lord, what I find, basically, Lord, there are 3 ingredients here. First is your lordships will find for use or permitted to be used.
Yes.
This is, Lord, one aspect. Then, Lord, it has to be a similar public resort. I mean, and there has to be a recreation or amusement for such purposes. Now, Lord, this has been, Lord, really speaking, dealt with, Lord, in that Bombay Wellington Club's case, where, Lord, they refused to obtain a license for the purpose of running an eatery inside the club through the club kitchen. These questions, Lord, whether it is a public premises, whether it is an amusement, has been gone through. But Lord, what is today troubling the Kolkata Municipal Corporation is this, that in the garb of a members club, if a public function is held, and in the course of public function, the benefit that the statute gives to the Kolkata Municipal Corporation, if that is lost, if the earning of the Kolkata Municipal is lost, they are not, Lord, targeting, Lord, the members or their personal venues, but, Lord, public functions. If they are held there, club has been held to be a public premises, because, Lord, the members are members of the public. That is how, Lord, the Wellington Club deals with it. But, Lord, the issue here is more fundamental. The issue is that if you are permitting the club premises to be used for an outsider's entry and public function, then why should you not be dealt with similarly as it is dealt with in any other public premises, if a function is held in any other public premises? Today, Lord, if somebody arranges a musical performance in any of these public premises.
But Mr. Kar, that will be restricted by their own bylaws also. If you actually see, all these clubs are set up and they function within the bylaws. And there's a strict provision in the bylaws where only the members are supposed to use it. This cannot be holding public functions.
Correct. But, Lord, when they engage,
and whether this public function, even after, if they apply, whether the permission can be given, not given, is a question mark, which...
Lord, I'll answer that. Today, Lord, we are only on this fundamental point. That, Lord, whether the corporation is targeting, Lord, a members party or a members function, or, Lord, they are targeting...
You're not targeting a members party or a members function.
I'm
You're
not.
targeting basically an event which attracts members who are of public, not only the restricted members of the club.
Correct. Absolutely. Absolutely.
That's what
and they are not invited through the members of.
They are not invited. They are not the guests of
the members. This is the
that I asked at the outset only. I asked
Yes.
Mr. Banerjee.
So, Lord, I just wanted to place those materials by way of an affidavit.
Yes.
Before your lordship's.
Yes. Those materials are relevant to ascertain the demand which you have raised.
Yes. And of course, Lord,
and also to adjudicate
correct,
on this
correct,
issue.
Correct.
All right.
Open invitation availability get.
In the event an affidavit is invited, I would be praying for an interim order not to give any effect till disposal of this particular application.
Interim order?
Because they are what they have
subject to.
Subject to. The
50%.
thing is, my contention had been
50%.
Open invitation.
My instructions are that we have the case over here, the prima facie case that we have sought to
You have to deposit something, sir. If you don't, then Mr. Carr.
Yes. I leave it to your lordship. Lord,
What do you say?
50% for the time being, then Lord,
that is something which perhaps I wouldn't be. The issue here is something which is very elementary.
We will decide the issue. It can't be decided or thrashed out today at the beginning.
At the threshold, that is what we have been attempting to satisfy your lordship on the point that this is this follows from the doctrine of mutuality. The club premises we have also indicated until
I would have agreed with your submission if I wouldn't have seen this and more materials which came.
And we have also. I believe we have also handed up the documents, where they have admitted, the portal has admitted
that is one of the portals which you have handed over the document.
But I have something to say on that also.
Yes.
But anyway, let me file an affidavit, then Lord, I'll join issue.
Because they have admitted the fact that the club had no role whatsoever in this particular advertisement being put up on the portal. So, if that be the scenario, what I'm humbly beseeching your lordship is gives us a short limited period of interim order, because the matter would be made returnable. We'll come back with the affidavit.
To give you interim order subject to some payment.
payment, perhaps we do not have instructions on that, my lord.
Get your instructions, payment as you don't need instruction, I'll pass an order.
Just gives me a moment, my lord, because we'll take the instruction.
Mr. Banerjee is coming, I guess.
He's on legs, my lord, but he'll be coming. But in the meantime, my lord, we'll just give
Can
us
I
a
ease
moment.
the situation for my learned?
Yes,
friend?
yes.
Let them, Lord, keep this 8 lakhs and odd, which is the demand, in their own bank account in a fixed deposit till the matter is decided. Because I think otherwise it will come heavily on my learned friend. So
Grateful to my learned
I'll ease the situation for. Let them keep it in a fixed deposit, separate account.
All right. The petitioner in the present writ petition is challenging the impugned demand issued by the respondent corporation under the head amusement fees. Demand is raised on 30th of
My lord, there have been several demands, my lord. The last
first
was
demand. Okay,
page
demands kar do.
39, my lord. 39 of the application.
Page 39, right?
39, my lord.
Demand being raised. It is the case of the petitioner that it is one of the pioneer clubs in the city. Full stop. The entry to the said club is strictly for the members of the club. Full stop. The club is managed by monthly subscription fees, entrance fees, and the income realized from the members who utilize the various facilities of the club, including the sale of food and beverages, and permitting the members and their guests to stay in rooms upon payment of certain charges. Full stop. Further, members of the club hold various functions from time to time at the club, and the entries of the same are restricted to the members of the club and their guests only. Full stop. The petitioner, earlier in the year 2002, received a demand from the respondent under the head amusement fees, inverted commas, and the petitioner challenged the said demand before this court in WPA number 4658 of 2003. The court, by order dated 26/6/2003, directed the respondent that any future demand made by the respondent authorities on account of the impugned fees would be subject to prior leave of the court. Full stop. It appears that the said writ petition was dismissed in default on 11/2/2015. Full stop. Now the petitioner has received a demand dated 1/3/2025 under the head amusement fees to the tune of rupees 8,35,500. Full stop. Being agreed by the same, the petitioner has preferred the present petition. Learned senior counsel for the petitioner, Mr. Ratnamko Banerjee, submits that the demands raised by the respondent, Calcutta Municipal Corporation, is illegal and void in law, since the provision under which the demand has been raised, section 422 under which the demand has been raised, are not applicable to the club. Full stop. Yes. Mr. Carr, before you leave. So, Mr. Banerjee.
Yes, Lord.
As far as the stay is concerned, so subject to deposit is what I was saying, of 50%.
Lord, keep it with Lord us.
That's what Mr. Carr has
That is
suggested.
what perhaps.
in his absence, I wanted to ease out the situation.
So, my lord,
for-
that is, my lord, I'm still absent, my lord, in that.
So he has suggested that
Very well. That's, my lord, a fair.
that should be kept
Since, my lord, is.
in a
Well, I would have
fixed deposit.
prayed for, my lord, unconditional stay, but, my lord, whatever, my lord, falls from the court, my lord, I fully, my lord.
All right, Mr. Karyuke.
full amount, let them keep it
50%.
as a
50%.
full amount.
The full
If they're
amount
keeping
whichever
the money
if
in
it's
their own
not-
account, investment, the interest that you earn is going to you only.
Yours only.
My lord,
50% you want 50. We'll keep
Lord,
it.
let them not keep the
club
entire.
would run away if we are ultimately
No, club has
held.
entire, I mean,
That
enough
one, Mr.
surplus to keep 8 lakhs separate.
50%. Well, let us keep, my lord, 50%, my lord, subject to, my lord, this decision, my lord,
Very
whatever.
well.
My lord, there is no.
This is further easing out of the situation.
Mr. Banerjee further, learned senior counsel for the petitioner, Mr. Banerjee further contends that the demand raised by the corporation is under a misconceived provision. Since the club is not holding any function for public purpose, and the events organized by the clubs are only for its members and their guests. Full stop. Learned counsel for the respondent, senior counsel for the respondent, KMC, Mr. Joydeep Kaur, refutes the said contention and states that the events which are being held by the club are not only restricted to its members and their guests, but are also being held for public, full stop. He states that the demand has been raised since the respondent corporation has come across advertisements on Book My Show, wherein the club, wherein the organizers have advertised that events are being held at the club for which the tickets are available to general public. Full stop. He seeks and is granted 4 weeks time to file his affidavit in opposition to substantiate his contention. Full stop. 2 weeks thereafter, reply, if any, thereafter. Full stop. In the meantime, subject to the petitioner keeping 50% of the demand raised by the respondent corporation within in a fixed deposit FDR and an interest-bearing FDR, the impugned demand of rupees 8,35,500 shall remain stayed for a period of usme FDR separately for this by the club, and the demand is stayed for a period of 8 weeks or until further order, whichever is earlier. Yes.
Lord, period of, my lord, interim order, my lord, is
8 weeks,
4 weeks, 2 weeks, very well, my lord.
8 weeks, or until further order, whichever is earlier. This is all right. You keep 50% in your
Yes, my lord, we'll do that immediately.
separately for this.
We'll do that immediately.
The FDR shall remain alive till for 8 weeks. All right. Or until further orders.
Or until further orders.
Whichever is list after we'll have it after 6 weeks.
Yes, my lord, just, my lord, that interim order, my lord, instead of 8, my lord, can it be 10? No, should disposal there. Of course, my lord, our request would have been till disposal, but I don't think, my lord, will my lord, 12 weeks, my lord, so then, my lord, just to have that
12 weeks.
Great. And after 6 weeks, my lord, 3 weeks
After
and 2
6
weeks.
weeks, we'll have.
I'm so grateful. So right to. We'll also not take steps because I don't know what book. We were also not aware of this. The fact that they have gone and put it in the book. We were not aware.
They have. See, this is the only thing which is troubling me, Mr.
We were not aware.
If you're,
I took them
if you make this statement, and this is how it will be, decided also. I'm just expressing my mind openly.
We'll write to them immediately.
If it is not for public, which you can't even do it.
Absolutely.
Because you can only do it for your guests, members and guests.
Yes.
But the moment you advertise, then you are attracted.
We had no idea. We actually had no idea. We were surprised. That's why, otherwise, when Mr. Kaur pointed this out, no, it's very important. Now that he's pointed out, we'll take steps.
And he says there are more documents to substantiate their content.
We'll take steps immediately. We were not aware.
You should stop this.
Well, absolutely.
Immediately stop this so that.
Absolutely. We'll take steps. I'm instructed.
I think that is how this matter will get.
Yes,
where
absolutely.
You will come ahead and give the statement that it will not be open for anybody to rent the venue and it is only for your guests.
Correct.
Your members.
That's how all clubs are. I'm surprised. I'm really surprised.
If you ask him, what did I ask him?
Yes, that is
he went back, I could not appear on that day. I was there from the.
This was my only question. And I kept asking him because then your judgment is attracted to the facts of the case. Because if it is not being used for public,
correct,
then there is no problem at all.
Absolutely.
Then their demand falls. Then the demand goes.
It is not for public, but I'll find out what book this banyan tree is doing because they're one of our sponsors.
Yeah.
I'm so grateful.
My lord, I appear for the petitioner led by Mr. Sankalp Narayan. He's appearing virtually, lordship.
May it please your lordship, I beg to appear for the petitioners.
My lord, with the leave of my learned senior, may I have your lordship's kind leave to file the supplementary affidavit, which...
What is there in the supplementary affidavit?
Whereas in the supplementary affidavit, we have appended an order by the Heritage Conservation Committee by which they had approved our proposal for seeking sanction. And we have also appended a reminder for seeking urban land clearance. So these are the only two documents.
Yes, we have.
Have you handed over?
My lord, we have served it upon the corporation.
Yes.
Now, in this case, the petitioner's institution had sought for a sanction from the corporation way back in the year 2015 for constructing a building in their premise. Now, the first letter in the said regard was sent on 28th of May 2015. And thereafter, there was another letter on 12th of May 2016. Now, my lord, since the school falls in the heritage list and the buildings are heritage buildings, the matters were referred to the Heritage Conservation Committee for their proposal in terms of Section 396 of the KMC Act of 1980. My lords, the Heritage Committee thereafter approved our proposal with certain alterations on 16th of May 2017. Thereafter, my lords, your lordships may kindly have a letter we sent to the Honorable Mayor of the city on 10th of July 2018, page 61. Well, that has the facts and our prayer, page 61 of the paper book.
Yes.
Well, this is a letter dated 10th of July 2018, wherein we have stated that at serial number 5 that an NOC from the Heritage Conservation Committee was already granted. And thereafter, if your lordships will turn to page 62, we have sought a sanction. And we have also stated that insofar as a clearance from the Urban Land Sealing Department is concerned, we submit that once the necessary clearance is received. This is Malala's page 62, third line. I'm sorry.
Have you got it, Mr. Narayan, the clearance?
My lord, now in the supplementary affidavit, we have appended 2 letters. Allows if your lordships would kindly have the supplementary affidavit. There is a letter dated 3rd of December 2018, page 7. Does your lordships have that?
Yes.
Page 7. To the competent authority under the Urban Land Sealing and Regulation Act 1976, 3rd of December 2018. Whereas the prayer is at page number 8, serial number 7. Now, whereas this was followed by a recent letter which we had sent, which is at page number 6. Whereas the fact is that till date we have not received this clearance. But my lord, this contingency, the legislation takes care of that. Because if your lordship would kindly have section 396(3), of the Act. 396 is exhaustive insofar as granting of sanction is concerned. Whereas 396(1) is sanction or provisional sanction or refusal of building or work. Now, as this prescribes that insofar as heritage building are concerned, an approval is to be taken from the mayor and council. That's the proviso to subsection 1. So that has been granted way back in the year 2017. Now, your lordships may kindly have subsection 3 of section 396. May I read that? If for the use of a building, a license or permission is required from any department of the government or statutory body under any law in force for the time being, and if such license or permission is not immediately available, a provisional sanction shall be given for the erection of such building, and upon the production of such license or permission and submission of duly authenticated copies thereof, sanction under subsection 1 shall be given. Now, my lord, subsection 4 thereafter provides, the municipal commissioner shall communicate the sanction or the provisional sanction to the person who has given notice under section 393, 393A or section 394. And where he refuses sanction or provisional sanction either on any of the grounds specified in subsection 2 or under section 405 or 406, he shall record a brief statement of his reasons for such refusal and shall communicate the refusal along with the reasons thereof to the person who has given the notice. So, my limited submission is that insofar as the urban land ceiling clearance is concerned, well, it is still awaited. We have been waiting for it since the past 7 years. So, my request is that this application may be decided. The matter has been pending since 2015. Because they may grant us a provisional sanction subject to us receiving a clearance from the urban land ceiling department, and that is what the provision also warrants. And they are also to communicate us with a decision by passing a resident speaking order.
Yes, Mr. Ghosh. Beside his application.
That initially now he has come with the supplementary affidavit.
Sorry?
Supplementary affidavit they have come.
Yes.
Giving certain documents and the facts.
Yes.
Which was not available in the main writ petition. Therefore, whatever the petition filed before lawsuit, the complete facts were not before the lawsuit court.
All right.
Now, the thing is this, my lord is saying that 2015 the plan was submitted.
Yes.
Now, we have seen there is a heritage building, the plan which is to be, the first of all, it is to be approved or not regarding the permission to erect a building on a heritage premises. Therefore, the plan which they intend to obtain the sanction, that is to be forwarded to the Heritage Conservation Committee, and then Heritage Conservation Committee will approve the same. Now, my lord, they have saying that in 2017 that was approved, not in 2015. That resolution is there. The initial proposal was G+7, I think, I find, my lord. That later on, they changed the proposal once again. And, my lord, in 2020, the agenda was prepared. Then 2020, they made a representation that they want to proceed with the construction, my lord, for the G+7. They want to make, my lord, G+3. That fact is, my lord, absent, my lord, in the petition and the supplementary affidavit. They made a representation to the Heritage Conservation Committee. That proposal was again considered by the Mayor and Council in 2022. Then they asked, my lord, to submit the true plan before the authority regarding the approval, how it is to be proposed, constructed. Then after that resolution in 2022, that resolution is with me, my lord. Yes. Then they did not file any, my lord, plan to the Heritage Conservation Committee for onward, my lord, forwarding to the building department to deal with the same. This is the position that there is no plan at all right now. Because you can see, my lord, the resolution, my lord, I am just placing it to lawsuit, my lord. You also can read, my lord, two folded pages.
Yes,
You
give
know,
it.
the second folded page is an agenda, and my lord, the first one is the resolution.
Resolved.
That is in 2022.
So what you are showing on this 13/5/2022 is the girls one that has already been approved.
So, my lord, 2022, my lord, that the proposal came at page, my lord, the agenda knowledge, see, my lord, that they say, my lord, the G+3, instead of G+7, my lord, G+3 to be constructed. And remaining part of the subject premises and that part of the building is recommended as grade 3 and remaining part of the is retained as grade 1 as per provisions of the act. Then that, my lord, the agenda was approved by the mayor in council. And they are asked to submit the plan. The letter was issued to the Supriyodhar Secretary of Lamartian School on 14 July 2022.
Yes, so initially, Mr. Narayan, you had made a proposal for G+7 and then subsequently you had changed it to G+6.
Yes, my lords, that all these proposals have been accepted and approved by the Heritage Commission Conservation Committee. It's not their case that these plans have, so either, my lords, it's either G+7 or G+3. These have been approved by the Heritage Conservation Committee. Now, my lords, my respectful submission is that in terms of 396(4), it's they who have to take a final decision on the matter. Because they may examine the documents, they may provide us with an opportunity of hearing whatever. If there is any irregularity, they may record
Well, I'm
reasons and
submitting
reject.
to your lordship with respect,
Just,
my lord.
he may allow me to just
Yes.
complete.
Yes.
Because
But I'm
if there
submitting
is
to
any, if there is any irregularity or non-compliance, well, it's obviously it's their decision.
Yes.
They have to grant us sanction or provisional sanction. Because they will provide us with an opportunity of hearing. We will provide them with whatever documents they want. They may dispose of this case. If there is any impediment, they may reject our case.
So today your proposal is for G+3.
Plus today my proposal is G+3. That was in terms of the suggestions which were given by the Heritage Conservation Committee. We have made alterations because there were some issues. Because any construction is subject to approval granted by the Heritage Conservation Committee because this is a heritage building. So we have to abide by that. Because they may dispose of this. That's the limited prayer as on day.
Well, I'm submitting, my lord, what I'm submitting, that G+3, which they proposed and accepted by the mayor in council, after the recommendation by the Heritage Conservation Committee, let them furnish, my lord, G+3, the proposal to the Heritage Conservation Committee, they will honor forward to the building department.
Mr. Ghosh, whatever you don't have, ask for it.
Well, with the mayor in council has asked for to submit the G+3 building. In the resolution itself, you are also requested to submit another 2 sets of plan proposal duly signed by the conservation architect and applicant so that the same can be forwarded to the building department.
Which page are you reading of?
This letter was forwarded to their the authority, the Mr. Supriyodhar, the secretary. You can see this letter. That is way back in 2022. Thereafter, no plan has been submitted.
So where are you reading, Mr.
Next page, you can see, my lord, of the letter. There is a request being made.
This is, they have already submitted that, Mr. Ghosh. This is, you have to figure it out. What initially had happened is all this has already been taken care of. Your facts are wrong.
My lord, this is the 22, my lord, that plan, my lord,
Mr.
after
Ghosh,
that.
initially they had submitted a plan for G+7 floors.
Right.
Subsequently, they have changed it. They have already.
That change, my lord, has not been submitted to us. That change, my lord, which has been submitted to us, my lord, now when it is in approved, they ask, my lord, 2 more copies to be forwarded.
That plan would have only been submitted to you after getting a consent from the Heritage Committee. The Heritage Committee has already approved their G+3.
Then, my lord,
and this has happened when? When is the approval from the Heritage Committee? What is the date?
In the 2022.
22. After that, Mr. Ghosh, this letter, this only says, this letter which you are relying upon, it is of 2022, which says, recommendation of the HCC has been approved by the Mayoring Council. You are requested to submit another 2 set of plan proposed, duly signed by the so-and-so department along with the sanction of the Heritage Committee.
Last month they also to ask them to some 2 more copies so that they could be forwarded to the building department.
Yes.
That was not done. Therefore, no building department has no the proposal with the building department. That is the reason. I could have done it.
Mr. Narayan, have
My
you
lord.
submitted?
Well, just one.
Are your plans there, Mr. Narayan?
Well, my plans are there, and there is one more instruction I've just received. Well, initially we had submitted G+7. Even G+7 was approved by the Heritage Conservation Committee.
That has changed, Mr. Narayan. Let's not complicate. Let's sort it
No,
out.
well, there's just one more thing. Well, G+3 followed only because they were not approving G+7. There is no impediment in G+7. Well, G+7 has also. My lord.
This is not an adversarial litigation.
Absolutely. Well, absolutely not. Absolutely.
So let us try to resolve it and find a solution.
My lord.
He is saying that you have not submitted the plan for G+3. Have you submitted it? If you have not, I'll pass an order where I'll give you time to submit it and they will decide the application.
My lord. My lord,
if you have submitted, then I'll record it that you have submitted it. Just tell me, seek instruction. Let me know the facts, Mr. Narayan.
My lord, absolutely. My lord, this is one more thing. Just one more thing. G+3 aside. We are intending to construct a G+7, which has already been approved by the Heritage Conservation Committee.
Today you are constructing G+3 or G+7?
Because we intend to construct G+7. We have been litigating for G+7 since 15. It was approved by the Heritage Conservation.
Then it is to be because they are changing now once again from G7 to 3, now 3 to 7. Now, if the 3 to 7, then matter again to be considered by the Heritage Conservation Committee.
No, there's just one. Yes. Lordships may kindly have. Lordships may kindly have my supplementary affidavit, page 17. Lordships may have from page 20.
Mr. Ghosh is very good in catching and complicating. So let's have absolute clarity.
Well, that's the intention.
He will swing me here, there, and make me a pendulum. Yes, Mr. Ghosh. Isn't it?
Submitting building is not available. Plan proposal is not available with us. That is the reason I'm submitting, my lord. Let me phrase, my lord.
Let us see.
Let a phrase, my lord. The document in place, my lord. We'll consider it accordingly.
My lord may just have for a moment page 20 of my supplementary. These are proceedings of the Heritage Committee.
Yes.
Page 20. This is the minutes of the meeting. Your lordships may have the first line under clause 2. The secretary of the so-and-so submitted a plan proposal for construction of G+7 story new school building at open terrace so-and-so, so-and-so. Resolution. The Heritage Conservation Committee on its meeting dated 27/10/16 decided to inspect the site. The site has been inspected by the members of the HCC on 9/11/16. Now the matter is being again placed before the Heritage Conservation Committee for further decision. Resolution. Vide a letter dated a letter of the Secretary of La Martiniere dated so and so mentioned that the portion where proposal is being proposed is vacant land at rear portion, that is a part of so and so thereof of the above mentioned premise. In view of above and subsequent site inspection report dated so and in compliance with the provisions under so and so, where proposal is being proposed may be recommended as grade 3 and so on. Now, this is after that, your lordships may have page 19. This is dated 27/4/17. Mayor and Council resolved serial number 2 that the matter relating to acceptance of recommendations of the Heritage Conservation Committee vide its meeting dated so and so for agenda 2 premises so and so is taken up for consideration and approved. Now, after the approval granted by
Mr. Narayan, Mr.
lord.
Ghosh is right to the extent. If you see the letter of 14/7/2022, it says the Heritage Conservation Committee, by its meeting dated 18/10/2019, recommended as follows.
My lord.
Previously, HCC, by its meeting dated, which you have just read,
My lord.
11/1/2017, had allowed the proposal for construction of G+7 story new building on vacant land so and so.
My lord.
Of late, Mr. Supriyodhar, on behalf of your school, submitted an application for construction of G+3 storied building in place of G+7 storied building, including so and so, so and so.
My lord.
Mr. Narayan, he is absolutely right. Now read further. The Heritage Committee in so and so has referred the case for inspection, and then the inspection has been done. He is right to the extent that you have been changing your stand. Initially, the committee had given a proposal. Then subsequently, you said you want to construct 3-storied. Today, what do you want to construct
Well,
and
yes,
what
yes.
permission you have? You
I
have to
may-
give clarity to this.
Yes, I'm giving clarity. Well, what happens is the matter is
Because
sent
what
before.
you have just read out, it's
Yes.
already there on record, the 2017 permission, which is there,
My lord.
2019 permission, and subsequently you yourself has changed your stand to G3, and now you have changed it to G7 again.
No. Page 17. My lords may have page 17.
I'm having page 17. Mr. Narayan.
Yes. So page 17, the subsequent plan which we submitted, that was approved. Page 18. Page
All right,
18.
what do you want? You want me to pass an order where I give a direction that you will submit the entire document and plan within X period, and they will decide it within Y period?
That
Or-
would, my lord, suffice.
All right.
That would suffice.
No, that will not suffice. Your friend is saying no. All right, see her finger, the way it is moving from here to there. Then in that case, let them file their report. We will
Well,
have
I-
clarity.
I
If you
may-
decide
I-
or your friend stops
No,
moving her
Malaz,
finger.
I have specific instructions. Malaz, this matter may be decided. They may provide us with the documents they are seeking within a prescribed period of time. We'll give them clarity on each and every facts. Some time frame may be prescribed, and this whole matter may be disposed of.
Mr.
Because
Ghosh,
this has been pending.
Your Lordship, my
Well,
lord, that gets respect, my lord, 22 resolution, your Lordship, seen of the Mayor and Council. If they want G+3, I have checked up with the building department that the building department, for one reason or other, because change
Mr.
person.
Ghosh,
My lord.
let's cut short the entire issue. Let them give all the documents to you. All right.
Along with the plan, they
Along
submit
with the plan, within a period of 2 weeks.
Yes.
You decided within a period of 4 weeks.
Well, I'll deal with them. What is the requirement, my lord?
Whatever, in
Well,
accordance
whatever.
with law, if
And my
there
lord,
is
that is to
any
be
shortcoming, any shortfall, you intimate them.
My lord. There, I'll do that. I'll do that.
Well, that is what 396
But
warrants.
that is no issue with me because anybody, my lord, can construct a building and it is submitted
you
to us.
have
We'll
to-
deal with that.
You have to issue notices to a person if they are falling short of any document. You can't sit over something, an application, and not do anything.
Actually, my lord, tell your lordship, your lordship, of course, my lord, may rebuke to us, my lord. But at the same time, if my lord is going on saying he should have, yes, he has to raise the construction, he should have any my lord flaw on our part, immediately should have come to the court. We could have response to that. None of the person, gentleman, everybody is my lord moving from one place to another place.
Since Mr. Ghosh, there's a school.
I'll do that, my lord. There's a difficulty because it is not an issue to argue. Because if yes, plan, my lord, to submit, my lord, it is to be dealt with, and my lord, it is to be done in accordance with law.
Correct. Absolutely.
Therefore, my lord, they let them, my lord, place whatever the documents needed to be, my lord, required by the authorities, my lord, they will intimate to that. And that plan proposal is to be submitted under the law through the, my lord, licensed building, my lord, architect or the licensed building surveyor.
Every document has to be in accordance with your 396, 395,
Yes.
whatever it is. You can't sanction anything when the documents are not there. You have
And
to
also the
satisfy
building,
yourself.
and also the building.
On the building. Yes, Mr. Narayan. Yes, madam.
Yes, Lordship, my instructions are let them decide on the G+7. The application.
Whatever you will file, the application, they will decide on that only.
Lordship,
My lord, that
Lordship,
would
my
serve the
lord, my
purpose.
Subject to their satisfaction.
Lordship, Lordship.
The petitioner has preferred the present writ petition being agreed by the inaction of the respondent corporation in not granting permission to the petitioner for construction of G+7-story building at petitioner number 1's institution situated at 14 Sarojini Naidu Sarani, ward number 63, borough number 7. It is the case of the petitioner that in pursuance of the Board of Governors resolution, in pursuance of the resolution of the Board of Governors, the petitioner applied for sanction of building plan for G+7-story building. Wide application dated 28/5/2015 and 10/7/2018. 28/5/2015 and 10/7/2018. Just check the dates, madam.
My lord.
If there's any, don't come back with correction.
No, Lordship.
All the chats can be outside the room. Just check the dates, 28/5/2015 and 10/7/2018.
Yes,
Full stop.
yes.
However, despite it is, however, the petitioner states that despite complying with all the necessary formalities, till date, the respondent corporation has not sanctioned the building plan. Full stop. Learned counsel for the respondent corporation submits that the authorities are willing and ready to consider and decide petitioners representation dated 28/5/2015 and 10/7/2018 in a time-bound manner. Full stop. Learned counsel for the petitioner submits that uske baad ek aur dal dena. Learned counsel for the respondent further states that the petitioners have not submitted the application. The petitioners have not submitted the entire documents and application to the satisfaction of the respondent authority. Full stop. Learned counsel for the respondent, Mr. Alok Kumar Ghosh, states that if the petitioner submits all the requisite documents along with the sanction plan, the respondent shall consider the said plan, said sanction within a period of 8 weeks. Within the period of 8 weeks from the date of submission to the satisfaction of the respondent authorities in terms of the statutes and the relevant building bylaws and rules. Learned counsel for the petitioner states that he shall submit a fresh, he shall submit a duplicate copy of all the plans and necessary approvals to the respondent corporation within a period of 2 weeks.
My lord, 2 weeks would suffice.
Within a period of 2 weeks to assist the respondent corporation in taking a decision within the time stipulated by this court. Anything else?
No, Your Lordship, my lord, that the plan which is to be submitted or the documents, along with the notice or proposal in terms of Rule 4, because that specifies what are the documents to be submitted. In terms of Rule 4 of the building rules.
Well, as your lordships may state in accordance with law.
In accordance with law.
That will cover everything.
Since your lordship directed to submit the plan and the document, that is the reason submitting.
Duplicate copy of the so and so. Full stop. With the above direction, the present writ petition is disposed of. In 8 weeks or 12 weeks, how much time you want?
12 weeks.
12 weeks. Let it give them time, Mr. Narayan. It's better.
Not a problem. Not a problem at all, my lords. Till the time they decide it, not a problem. I'm grateful, my lords.
Within a period of 12 weeks.
Much obliged.
Supplementary affidavit is taken on.
Much obliged, my lord.
Deeply obliged, my lord.
Only submitting, my lord, that you know, say the duplicate plan, duplicate or phrase, whatever it may be, because option we get with.
See, the reason I'm using the word duplicate, Mr. Ghosh, is because
I follow.
You will say new plan,
Yes.
new application.
No,
That's
no,
why I
they,
use.
they, my lord, what they are asking for, my lord, they, whatever they submit to them, my lord, of course. Well, only I'm
I
submitting,
don't want you to tomorrow say, because the court had given this order that you were supposed to make an application, a new application, we will consider it afresh.
Yes.
Application is there.
It's all the
They
same, my
will-
lord, because
they will-
ultimately it is to be considered and disposed of. My lord, ultimately
That is
it
the ul-
it is
that
to
is
be
the
considered and disposed of. My lord,
Correct.
whether, my lord, the previous application or present application, this is
It has-
disposed of.
absolutely.
That is your final, my lord, order. But all the only I'm submitting, my lord, that since he has, my lord, made the petition, the allegations were because I have not, you know,
Yes, yes.
called for, my lord, the affidavit, my lord.
Yeah. All the allegations are, since this court has not, since the affidavits are not been exchanged, none of the allegations are admitted. A particular line, that paragraph.
Obliged, my lords. Much.
Mr. Ghosh, you always.
You should allow me, my lord, to assist your lordship in the manner, because you should don't, my lord, take that impression that I am objecting, but my endeavor as a lawyer in this, my lord, profession, I assist the bench, my lord, in a way the order to be passed.
I
For
will,
effective adjudication.
for next week, I'm really looking forward to that assistance in that owner-occupier matter.
Well, I, in both ways, I can argue the case.
You know, because that is.
But if I will argue there for the
Mr.
defense, I can also argue for the petitioner.
That's right.
That one of the recommend I have, I can argue.
That's why I always,
know, my lord.
I always
Because
recommend.
I know, my lord, for the first time, I am telling your lordship, whenever the clients come, but I don't all the time, my lord, they don't ask them, my lord, to come to the approach the court.
Yes.
If I can, my lord, make them understand
Ghosh,
that it is no good for
let-
coming to the court.
Let me tell you one thing.
My lord.
Your understanding of municipal law is very good. And you have been doing it for ages. You know exactly how to assist the court.
No, I am not asking for the assistance. They are now, I am to deal with a public authority also at the same time.
Yes.
The public authority problem has to be looked into by myself also.
That's
when, my
correct.
lord, when I am approaching the court, well, I cannot go, my lord, in the way that my public authority will be in a ditch. But there too, my lord, how they to be resolve the entire issue.
There, Mr. Ghosh, I have a comment. First, you are officer of the court.
Right. My assistance, my lord, in both ways, because the ultimate
First, the
proper
assistance should
effective
come to the.
adjudication.
Yes.
Proper effective adjudication. That is not the primary consideration of the bench, and my duty is to assist in
So
that way.
Next week we will see in the owner-occupier matters. We will see the assistance. All right. I'll be back in 5.
Mukherjee has suffered a bereavement in the family. He's away in Patna. So he has requested me, my lord, to pray for an adjournment before your lordship today.
Proxy counsel so and so appears and states that the main arguing counsel, Mr. Pankaj Mukherjee, has suffered a bereavement in the family. He requests for an adjournment. Let this matter be adjourned for 2 weeks.
But next week he will be here. I had a word.
You tell me you want next week or 2 weeks?
Next week, my lord, next week.
Next week. Great.
Item number 10, Mr. Raghunath Chakraborty is appearing for the petitioner. He is addressing the Honorable Division Bench. Would your lordship kindly pass it over for some time?
Passover won't be possible, madam. We have a
Thursday, my lord. I am for the private respondent, my lord.
My lord, tell me.
at the request of the learned counsel of the petitioner, let this matter be listed next Thursday.
Let it retain your position. Let it retain its position, my lord, in the list. And gratefully, your lordship.
Item 11, my lord, I am appearing for the petitioner, my lord. My lord, I am appearing for the petitioner. This is a matter regarding to illegal construction, my lord.
But I am appearing on behalf of
his lordship,
Kolkata Municipal Corporation.
Under directed for a demolition proceeding to the executive engineer, my lord. And executive engineer, after hearing my lord both sides, has passed an order on 8th of February 2025 with regard to section 400 and 401 of PMC, my lord. Till now, nothing has been done, my lord. No issue of notice has been done, nothing has been done.
Who appears for the KMC?
My lord, I am appearing.
Yes.
Lord, kindly give me 1 week time, my lord, so that I can take instruction from the authorities.
My lord, there was a time with regard to instruction, my lord.
That instruction has not yet, my lord, I have received, my lord. I am led by Mr. Sandeepan Banerjee in this matter. Lordship, kindly give me another 1 week time.
Next week, not today.
My lord, in item number 11, I beg to appear on behalf of the private respondents.
Not today, sir.
My lord.
Next week.
Yes, Lord.
Item number 12, this is my application.
I'm
Mr.
appealing for the writ petitioners in this matter.
Chaudhary happens to lead me in this matter. Lordship, I'm praying for a short passover on his ground. He's on his legs in another courtroom.
Not today.
Lordship,
When is the matter coming up? On 3/7. Keep it on 3/7. 3rd of July. 3rd of July.
Could we file our affidavits?
No.
Your Lordship, perhaps this would not require affidavits to be filed, Your Lordship, given the wisdom of
Just
your
leave
Lordship.
whether we'll see whether you need to be pleaded or not.
Yes, on that IA.
Third, list it on at the request of the parties. Let this matter be listed on 3rd of July. At the request of the petitioner, let this matter be listed.
3rd of July, my lord, I got
3rd of July, my lord, today.
17th, whenever the matter is.
whenever the matter is. It's on the 17th.
17th
Kobe
written after 4 weeks. The affidavit direction was given 3 weeks, 1 week.
31st July.
Maybe. Without prejudice, we could have used an affidavit.
31st July. Whenever, whatever the date is. भूल हो गया. Change करो. Take down. The order dated July 3rd, 2025 is an inadvertent error has crept into the order dated 3rd July 2025, wherein WPO number 256
or date change
of 2025 has been noted as
up to 4 weeks.
WPO number 256 of 2024.
25.
Necessary correction shall be.
The main matter is coming up 4 weeks after 3rd of July.
3rd July.
So returnable 4 weeks thereafter.
So, my lord, in terms of your lordship, what had fallen, my lord, we have taken out the application, my lord.
You will see the
This is my application.
My lord, I appear for the Kolkata Municipal Corporation, led by Mr. Rishi.
My lord, this writ application filed by the petitioner only for the extension of time for implementation of the order passed by the Honorable Justice Ashish Kumar Chakraborty. My lord, page 43 is the brief দিয়ে না, brief page, ঠিক আছে, thank you. Start from page 43. My lord, that order has been passed by Justice Chakraborty with presence of the all of the contesting parties, and order has been passed on 9th June 2016. But I only praying for this operating portion on the page 46, last paragraph. In view of the above submission of Mr. Hawk made on behalf of the respondent corporation and its officer leads the respondent number 2, the municipal commissioner held a hearing within June 30th, 2016 upon notice to the petitioner through their advocate on record in the present writ petition and the respondent number 5 and passed a reasoned decision with regard to the change of the recording the name of the owner in respect of said premises, originally numbered premises number 17 Goriahat Road, Kolkata, in the municipal assess inspection book, respondent on appearing annexer P7 of the to the writ petition and the claim of the petitioner to mutate their name in respect of the said premises. During the course of hearing before the learned municipal commissioner, the parties shall be entitled to rely on the copies of the writ petition and the copies of the affidavit filed by the respective parties in this writ petition. The municipal commissioner shall communicate his reasoned decision to the petitioner through their advocate on record.
Sir,
in this
what you are stating, what you are arguing is not reflecting from the pleading. In your prayer clause, what are you asking for?
My PR is the my name has been mutated in the assessment register. Practically, this is not a Thika property, but I've taken lease from this owner and for 1999 years. After I go to the Calcutta Municipal Corporation, for my name has been mutated on the said premises, but subsequently the find out, if your lordship kindly come to page 42. Premises number B/17/H/H. That H means the Thika property. If the property under the Thika Tenancy Act, then the property already been vested in the state, then that will be treated as a Thika property. But there is no whisper, anything, even Thika controller, there is the Thika property. But in spite of that, in the assessment register of the Kolkata Municipal Corporation, there is the indication, the H. And on the basis of that, my name has not been mutated. But subsequently, this is the find out that the one deed application has been filed in the year 2015, when the then owner of the property filed this deed application, and on the basis of that deed application, the Honorable Justice Ashish Kumar Chakraborty directed to the Calcutta Municipal Corporation to consider and dispose of regarding the mutation. And on that basis, I am paying before your lordship only to extend the time for hearing those of party by the municipal corporation and dispose of the same. If that order,
it's a 2015. We are sitting in 2025, sir. 10 years.
9 years. Order for 2016. It should writ application has been
You want extension of an order which has been passed 9 years ago. I'm not able to follow what is your prayer.
Hearing took place before the municipal commissioner.
Yes.
The learned advocate represented the petitioner in that writ petition, attended the hearing, order copy was given to him. In that order, municipal commissioner requested the Thika controller to decide whether it is a Thika property or not, because Thika controller is the appropriate authority to decide whether a property is Thika property or not. Thereafter, hearing took place before the Thika controller. Thika controller decided that the property is a Thika property, and 2-3 assessees who were in possession, who filed their returns, have been declared as Thika tenants therein, and few assessees who did not appear before the Thika controller, their status has not yet been decided in respect of that property. But the crux of the matter is that it has been declared as a Thika property by the Thika controller. May I hand over some papers, my lord?
So you challenge that if you have to.
Yes, if your lordship kindly directed to the file an affidavit in opposition, I will.
Why should there be an affidavit of opposition?
Otherwise, I will obtain the order passed by the Tika controller.
I'll give you a copy of the order.
Your lordship directed.
For this, you don't have to get
If that is the Tika property, this court has no jurisdiction. The land administrative tribunal is the jurisdiction. But
My lord, this is the order that I have opened before your lordship. The next page, the third row is the advocate on record of the petitioner received that order. Thereafter comes the Thika controller's order, my lord.
হ্যাঁ এটা তো বলেনি তো আরে এটা তো সেই বিগ পিটিশনটা তো এইখানে তারপরে দেখাচ্ছি না না সব হয়েছে
Order has already been passed by the commissioner.
But if the order has been passed, I am not to say anything. But if their property total
It's a
29
Thika
katas,
property, sir.
29 katas, 13 chota.
Sir, go before the Thika controller.
Video, if your lordship kindly handed over the directed to my learned friend to handed over the copy of this application, I will.
The lordship would kindly see to
What kind of petition he has filed? I just don't
he
understand.
ends at the order passed by my lord justice Ashish Chakraborty
No,
as his
look-
lordship then was the last annexure in your lordship's brief.
That's right, but
And thereafter all these things have happened. There is no reference to all
Nothing.
this.
2016, you're coming in 2025.
I am subsequent leasing. The 2015
nobody-
read application has been filed with the original one, Mr. Raja.
Sir, if you want a modification of that order,
No, I am not to modified that order.
what do you want?
I want to only extend the time for implementation of the state order. During that period, if any.
Sir, if you want any change in the order, then you file an application. Today, your prayer clause is entirely different from what the submissions you're making. Look at the prayer clause, Mr. Mukherjee.
Yes,
Submission is something else, petition is something else.
Incorporate the name, that is mutation under 183. He is seeking
No.
under 183 to incorporate his name. in the
Incorporate
record.
the name of the petitioner in municipal assessment registered as leasee after deleting the letter H.
That happens only in.
I'll dismiss it. He won't even have a right before the Tika tender. He can't go anywhere.
But only I am paying to.
No, sir, these
those
kind of
those
petitions-
paper me handed over. I am not.
Sir,
Those paper which has been.
file RTI. File RTI, get the papers. This petitions just filed like nobody's business. Can't just burden the court like this. Cost should be imposed for these kind of petitions. Nothing is done, just petitions filed. Give a copy of this
I'll just give him.
front page.
Yes, my lord.
Learned
I've
counsel,
got
the
a
petitioner seeks to withdraw the present petition. The same is dismissed as withdrawn. Since
Great.
just give him the front page of that.
This is my writ petition one in item 14. Now, this is challenging an order passed by the Kolkata Municipal Corporation Assessment, my lord, where because I was paying, according to them, 80.94% of the total rent collected from the property, I have been foisted with 80.94% of the total municipal taxes, which in my humble submission, subject to my law testing, of course, is a concept alien to the Kolkata Municipal Corporation Act. But I am occupying not even an area of 10% in the property. My lord, the landlords had inducted several other tenants, and I shall take your lordship to the
You're
order.
also one of the tenants.
I was one of the tenants. I had left in 2015. It is now that the assessment order has been, this order has been passed. But before I take your lordship to the documents, may I in a nutshell indicate the broad contours of my argument? My lord,
First, narrate the facts of the case.
I'm sorry, my lord.
Facts.
Yes. My lord, I entered into an agreement for lease for around 20 years with the landlord.
Yes.
My lord, that lease deed is dated, my lord, 13th of November 1991.
Yes.
My lord, my area is 5441 square feet. 5541, I'm sorry, 5541 square feet. But this would be of some bearing, my lord. Your lordship would kindly take a note of this area, and I shall tell your lordship why. My lord, as per the agreement clause, I was foisted with the property tax liability to the extent of the space occupied. That is specific clause 4A. I'll take your lordship to that. My lord, we handed over possession in 2015, 30th of April 2015. But in the meantime, for a particular period, the rent was attached by the Kolkata Municipal Corporation on account of unpaid property tax dues. So, my lord, on that account, our rent, which were attached, aggregated to rupees 36 lakhs, which was attached and taken by the Kolkata Municipal Corporation. But there was an unilateral annual valuation revision which had taken place. No notice of hearing given to us. But in, thereafter, my lord, we had challenged in by way of a writ petition. The Honorable Writ Court, my lord, disposed of the writ petition, directing that a fresh adjudication be done upon giving a notice of hearing, and directed us to make payment of around 1.7 crores without prejudice to our rights, which we deposit. So, my lord, as on date, 1.7 crores we have deposited, and 36 lakhs, which was by way of attachment of our rent, is lying. So, my lord, 2.06 crores is already, my lord, lying with the, my lord, Kolkata Municipal Corporation in suspense account. My lord, then the reassessment hearing is done. My lord, the hearing is once again done. And finally, the order which has been passed, which is impugned before your lordship.
But why are you here? Why you're not before the
building tribe assessment? Yes, yes. I'll tell your lordship why. But my humble submission, and your lordship would test that, of course, is that this order passed is ex facie without jurisdiction. And my lord, I am covered by an honorable Supreme Court judgment and also a division bench judgment that if the jurisdictional fact is not, my lord, appreciated in the proper direction, then that order, my lord, the alternative remedy would not be a bar to the writ petition. I'll try and satisfy your lordship on that. But may I just indicate, my lord, what would be the contours of my argument? A, I need to cross that hurdle of why writ court and why not the assessment tribunal. I shall have to cross that. I shall have to satisfy your lordship. Main crux of my argument is, my lord, the assessment has been made on the basis of the actual rent which is there of all the tenants. So, my lord, it happens so that some of the tenants are occupying a much larger area but paying a lesser rent. I am occupying a smaller area, but I am paying a higher rent. Somebody is there in the property for a paltry figure of 2,000 rupees, whereas my rent is around more than 1 lakh. So, my lord, what the assessment order finally is, they have totaled the rent, which comes to say, I'm giving a ballpark figure, my lord, it comes to, my lord, 2 lakhs. Since I have my rent is, my lord, 1,60,000, which is 80% of the total rent, they are saying you pay 80% of the tax. This, in my humble submission, is a concept, in my humble understanding, alien to the Kolkata Municipal Corporation Act, as well as the judgments of this Honorable Court, as well as the Supreme Court, which says that, my lord, actual rent cannot form the basis of, my lord, the assessment, and it should really be the reasonable rent which the property can fetch. So, my lord, what a reasonable rent would be for me would also be to my next door neighbor of the same building who is paying paltry amount of maybe 5 rupees a square foot. So, my lord, because the landlord and that tenant had struck a deal of a better rate, that would not give the Kolkata Municipal Corporation the leverage to, my lord, claim separate amounts or, my lord, apportion separate amounts for separate tenants. Because the annual valuation is for a whole building. Now, my lord, because my rent comes to, my lord, 80%, that would not foist 80% of the tax liability on me. So, my lord, in that event, my lord, if this reasonable rent letting out value as per section 174 of the Act is followed, then for all the portions, the reasonable letting out value would be much more. So, if that be the case, for a person who is there in the property for 2,000 rupees a month, for that portion also, the reasonable letting out value would be much more. So, if that is the situation, then 80% of the rent is something which would not be available for the Kolkata Municipal Corporation to take in the order. That is my scope of challenge in the writ petition. So I say that the applicability of the provision of the Kolkata Municipal Act has not been done at all in the order, which makes the order ex facie void. May I take your lordship straight away to the order, and then I'll give your lordship the.
No, but what is the difficulty in going to the tribunal because you have to deposit some money?
My money is already lying deposit. I have already deposited 2.06 crores. Money is not the factor.
This aspect can be looked into by the tribunal also.
But my lord, may I humbly beseech one thing, subject to what falls from your lordship. This possibly
specialized tribunals dealing with tax issues. Why should a writ court be burdened with these issues?
In my humble,
I totally understand. We find judgments alternate.
But I would try and persuade your lordship to this extent that if your lordship finds that the invocation of the provision per se is wrongful, then your lordship would exercise your lordship's discretionary jurisdiction. I'm fully aware to the fact that it's a discretionary jurisdiction your lordship may not want to entertain. But if I can try and satisfy your lordship that the application of the provision was not even done.
What is holding you from going there? This aspect can be easily looked into by the tribunal.
But this would be a point which your lordships would appreciate.
Body looking into this aspect.
But this would really be a point which your lordships would appreciate much better than the tribunal. Okay. And because it's a jurisdictional fact involved. May I try and satisfy your lordship?
They are not tax experts. They are.
No, but if your lordship sees that the provision has not been appointed at all, that is why, my lord, I would be saying that this order itself is without jurisdiction. This is what my argument would be, subject to my lord's kind consideration of that. May I take your lordship to that provision once? Kindly takes a look at, my lord, section 174 of the Act. But in this case, the pre-amended provisions would be applicable. Pre-amended provisions, my lord. If your lordship kindly takes.
You appear, Mr. Banerjee, for
the owner, my lord. For the owner.
For the owner.
For the owner.
For the owner, and the owner also has a separate writ petition, which is the next matter.
Item 15.
Which is the next matter.
So why both of you are not going there?
Mine is a question of apportionment of liability, which the tribunal does not have jurisdiction. I am not challenging or disputing the annual valuations. I am saying once you have apportioned the liabilities amongst the tenants, then Corporation Act is an enabler. It says, I am the person on whom it is primarily leviable. So you serve your bill. Corporation ordinarily serves its bill on the owner and says, I'll take the entire money from the owner. And then owners should take reimbursement from the occupiers. That's what they do. I am saying, since the Supreme Court has said that each occupier is also a person liable to pay taxes, if his portion is worked out, you directly take it from the occupier. That's provided now under Calcutta Gujarati. That's what I'm trying to bring in. Tribunal can't go into this. Tribunal can only 189 subsection 5 can go into the merits of the or demerits of an order of a hearing officer passed under section 188. That's all. I am not challenging the valuation. I am challenging a portion.
Mr. Mukherjee.
First, see the prayer. The prayer is
which first
Canara Bank's prayer.
Canara.
Page 24, your lordship sees declaration to issue that the letter dated 15 July 2022, along with the order dated 18th May 2022, being annexure P15 hereof is not applicable or enforceable against the writ petition. Now, my lord, this order of the corporation your lordship gets, volume 2, page 161 of Canara Bank's.
No, I'm only asking Mr. Banerjee about
Just 1 minute. Is it maintainable at this stage? If your lordship kindly sees 168, the last two paragraphs. Last two paragraphs. As the power to make amendment in existing assessment under 192 is vested upon municipal commissioner. So the matter will be placed before the municipal commissioner for necessary amendments of the assessments as above, and after approval of the same by the municipal commissioner, notices will be served mentioning the proposed annual valuations for the respective periods to the recorded owners, that is the petitioners under 184, that is Mr. Banerjee is appearing, and an examination of the proposed annual valuation will be done as per law. After determination of the annual valuation of the respective periods, the proportionality of the property tax for Canara Bank and the owner and other occupiers in respect of 7 Red Cross Place will be communicated to the recorded owner, that is the petitioners and the respondents. So, my lord, this petition, my lord, in my most respectful submission with all humility, is premature. It is yet to be done. And my lord, your lordship has heard Mr. Banerjee saying that he is not joining an issue with the valuation. He is only insisting upon pay your part of tax because he is the owner. He doesn't want to saddle, he doesn't want to be saddled with the tax of the entire property because others are utilizing it for commercial purpose. He has just rented it out. Yes. So in this factual scenario, I was just asking a question to myself, would this honorable court sitting in its high prerogative jurisdiction go into all this?
May I just sum it up, my lord, in just 1
Sir,
minute, if you
sir,
like.
may I?
Just sum it up once.
I'm in no hurry, sir.
Yes.
Just sum it up once what the actual dispute is. Canara Bank holds a portion of the premises in question. Admittedly, the premises is a valuable premises. It's been assessed for taxes.
5541 square.
Yes, it holds a portion, but because it's a bank, it gives a humongous amount of rent. The rent is higher than the normal rent. Because it's a bank and bank only wants your ground floor or the first floor, otherwise it can't function properly. ATM spaces, lockers and all. So when initially the owners came forward in a writ petition earlier before this honorable court, their grievance was that this hearing ought to be made of assessment, ought to be made after giving all the tenants an opportunity of hearing, and there should be splitting up of their liabilities also mentioned. For instance, X is 45%, Y so and so percent. This liability splitting up is done in terms of section 195, read with 230, where the ratio of the annual valuation of the concerned portion bearing as to the entire annual valuation of the building is taken to be the percentage. So we wanted that to be done by the hearing officer or the assessor collector so that everyone knows regarding his portion how much is due and payable. So, my lord, an honorable single judge of this honorable court disposed of our writ petition by making a two-pronged order. Firstly, his lordship was pleased to say, up to 2011-12, that is the period till which assessments have already been made, please apportion the amount of taxes payable by each tenant and to the owner-occupied portion, if any. Thereafter, recover it. As far as 2011-12 onwards is concerned, because it's the case of the owner that none of the tenants have been heard, please call everyone on the same table, hear out their grievances, and then pass appropriate orders fixing the annual valuations and distributing the proportionate amount of taxes. The second part has been done. The first part, pro rata division of the earlier taxes, that has also been done. Everyone has been heard. He's been heard, I have been heard. Now, my lord, I have come up only on a limited point. I say, I am happy with the fact that it has been split up.
So Canara Bank has to unfortunately bear the brunt of the maximum amount of taxes. I am the non-occupier owner, so I will only get a proportionate share of the taxes which I have to pay. But Corporation Act says person primarily leviable is me. So the entire multi-crore demand will come on me first.
Right.
I don't have enough money to pay.
Right.
Therefore, please split it up so that each of the occupiers pays directly to the corporation. That's my limited, attack in my writ petition. I'm not going against valuation. I'm not challenging their apportionment also. Tenant comes and says something. Tenant says, I am Canara Bank. I'm in occupation of 5,000. Someone else is in occupation of 5,000 also. But for my 5,000, I am paying, let us say, 10 lakh rupees per month. And that someone else for his 5,000 is paying 10,000 rupees per month. So why should the apportionment of liability be on the basis of actual rents paid? And why not on the basis of area occupied? That's what he's saying. Now, matter has been sent to the municipal commissioner because after the assessor collector has heard it, he has proposed certain reopenings of annual valuation qua the directions made by this honorable court. That assessor can't do. It has been sent, I think, before the municipal commissioner. Municipal commissioner will consider this matter, exercise his jurisdiction.
When it is pending, then why have you come here today?
What I suggest is not if
He was hard at the first place.
even in under 192, you all have to hear everyone.
That is what the direction is. That everyone needs to be hard.
So if he can raise his grievance before the commissioner, it can be over.
And
I can also go there. I can make that prayer.
Can also make that
His initial argument.
Well, I do not have that instructions as of now.
because then it is premature,
We
sir.
do not have that instructions as of now that it has been reopened. I do not know.
That's the order.
Is the one
Order?
No. That does not say. Kindly seize that order.
Notices have to be issued.
168.
Kindly seize thereafter what happens after 168. Kindly seize page 170. The ordering portion apportions that amount
Up to 2011, 12.
and foists it on us. Kindly see, that is why we have come. Otherwise, we would have no occasion to come. Kindly seize page 170.
Yes.
Kindly seize, it has been said the total tax liability of Canara Bank is 4 crore 15 out of 4 crore 75. So it is already there.
Other liabilities, page 170.
So it's out of 4.75 crores. I have already been foisted with 4.15. Let this order go, we shall go.
Why this order would go? It was given, you were given a hearing, you have raised your objection.
That is why I am complaining.
How many times will you
Then the
raise-
submission is that it has been reopened. Then this is not any reopening. If this order stays, it's not any reopening.
Lord, may I assist your lordship, Lord, on this? Please come to page 169. The scenario will be clear. Please come to 169. My learned friend will perhaps get his answer there.
Yes.
This honorable court said up to third quarter 2010-2011, please apportion. And therefore, that's what they have done. Miss Lord kindly sees first line of page 169, may I please? However, considering the existing assessment of the premises till third quarter 2010-2011, pro rata liability of outstanding property tax of the occupant Canara Bank and the owner and other occupiers in premises number 7 Red Cross Place, SSC number so and so is shown below.
Yes.
And Milord kindly sees the entire demand calculation of property taxes from fourth quarter 1983
Yes.
to fourth quarter 1991 was principal 5 lakhs and odd, interest 12 lakhs and odd, penalty 70,000, total 18 lakhs. Now, this only up to fourth quarter 1991. Now, Milord comes to the table just below that.
Yes.
From first quarter 1992, that's the third table, the bigger table.
Yes.
First quarter 1992 to third quarter 97.
Yes.
Then fourth quarter 97 to third quarter 2004.
Yes.
Then fourth quarter 2004 to third quarter 2010. And then total up to third quarter 2010-11 is 4 crore 57 is the total outstanding, out of which liability of Canara Bank in terms of the apportionment of taxes already done is 4 crore 15. Liability of other occupiers is 42,581. So this had to be done in terms of the order of this honorable court as made earlier. Regarding the subsequent periods, 2010-11 afterwards, there he proposes certain valuations and he sends it, Milord, to the municipal commissioner. Please come to page 168. 168, the last part.
Yes.
Please come to the last paragraph.
Yes.
Second last and last. As the power to make amendment in existing assessment under 192 is vested upon municipal commissioner under KMC Act 1980, so the matter will be placed before the municipal commissioner for necessary amendments of assessments
as above, and after approval of the same by the municipal commissioner, notices will be served mentioning the proposed annual valuations for the respective periods, so that the recorded owners, i.e. petitioners, Amarnath Roy and others, that's us, under section 184 of the KMC Act 1980, and determination of the proposed annual valuation will be done as per law. After determination of the annual valuations for respective periods from fourth quarter 2010-11, my lord kindly sees, till fourth quarter 22-23, that's the second slab, the proportionate liability of property tax for Canara Bank and the owner and other occupiers in respect of premises number 7 Red Cross Place will be communicated to the recorded owners, petitioners, and the respondent Canara Bank. So the first slab, apportionment has been granted. The second slab, assessments are due. They have been placed before the commissioner for hearing in the presence of all the parties. So this order is in that way unexceptionable. The only part where I have challenged is
he's challenging the first part.
Yes,
I'm grateful.
He's saying
he's challenging it before 2011.
Yes,
he's challenging the
liability up to
liability from literally from 83
from 73, 74 to 2010, 2011.
Third quarter 2010.
Third quarter 2010.
This he says the percentage of liability, my lord, kindly comes to 169.
So, Mr. Mukherjee, what is pending is subsequent period.
Yes.
So I am
He's not
this.
challenging subsequent period.
I am not concerned because
So
I've
to
left
say that the proceedings are pending before the municipal corporation, it is pending for the subsequent years.
Right.
Not for this year.
For
He's
the
challenging it for
period,
the.
what we have done, it was in compliance of the court's order.
No, that is
I'm challenging that.
Yeah, the right.
Challenging that.
And it was done after giving him a hearing.
That's all right.
Well, very well. If your lordship wants,
Whatever
I
it
can
is,
explain it.
That is entitled to
That
challenge.
is entitled to
Very well.
challenge.
Let him challenge, my lord. I will explain it.
That is entitled to challenge.
What he challenges, my lord, is the percentage. My lord comes to 169.
The only thing by which the tax liability has been affixed upon you is not only by the space which has been occupied by you, but by the quantum of the rent.
Yes, your lordship
And that is
kindly.
exactly what, to my understanding, I mean, prima facie view, I'm of the view that it has to be affixed on the rent.
Yes,
On the rent.
My
lord, why I humbly try and persuade your lordship
Because
otherwise.
the impression which you are giving is that the rental, suppose the rent is 10 rupees, you are paying 8 rupees. All right. So on 8 rupees, you are saying that, it is almost 80% I am paying.
But I am actually in occupation of 20%.
My lord,
But
could
then is the rent what matters?
I understand what is troubling your lordship. My lord, could I humbly beseech your lordship? I understand. I'll try and persuade your lordship otherwise. But may I just indicate one thing? একটু আমি বলিনি আমার রিট পিটিশন একটু আমি বলি
That's the Delhi Act, that's the Calcutta Act.
That's what
Yes.
I am aware
My
of.
lord,
I will see the
Yes,
Calcutta.
my lord, what I'll try and persuade your lordship with is that, my lord, then the concept of reasonable letting out value for the other portions would not be there. Then everybody who will be paying at 10 rupees a month, then that building, the annual valuation would be 50 rupees. That is not permissible under the KMC Act.
There's an answer. No, there's an answer.
So I'll go to that route. Let me make my submissions.
I'm sorry. I immediately, I'll quite enough.
So, my lord, that I shall show from the judgments and also the tenor of the act, and also by a division bench also and a Supreme Court, that the actual rent cannot form the basis of the annual valuation. It always has to be the reasonable letting out value. Otherwise, the KMC Act, my lord, would be. But I shall show from the judgments. But I shall show. I'll try and all I can do is, my lord, I can try and persuade. I'll try.
What he would be referring to,
the single
Indian automobile.
That's all right.
Yes, India automobile and also.
Line answer to his question is,
I mean, that
reasonable rental is relevant for the purpose of assessment. It's not relevant for the purpose of apportionment. Once you have assessed, the monies will be apportioned in terms of actual rent. That's the single.
I'll join that conduit. I'll try and join that conduit. Why it is also.
He will hear you. He'll hear you. But not today because we have a specially fixed matter at 2 p.m.
Yes.
Next week.
Next week.
Absolutely. We shall be there next Thursday. But both me and Mr. Shah was in some difficulty at 2 p.m. So I'm glad.
We have a specially fixed matter next week.
Next
This matter be listed next week. Not today. Not today. I'm simply making it not today. Next.
Not a one-line order would do. It's
You're not appearing for corporation.
Yes, it's Canara Bank.
Bank also doesn't pay you. All right. At the request,
Effective hearing. Every effective hearing.
at the request of the parties, let this matter be listed next week.
I'm grateful.
Grateful.
Next up. We have a specially fixed matter, so
This will go on. This will
Yes.
go on for a while.
There's the rest of the matters, the board is discharged.
Yes.
The rest of the matters we can't take it.
Take it up next.
2 p.m.
Huh?
At 3 p.m. I have a
Lordship has a bench. This will take time,
Division
but
bench.
I'll go slowly. I'll go slowly. I'll start.
কারো উপরে ভিত্তি করে কিন্তু
After lunch.
এরপরে
This is the Sahujan matter.
Lord, before my learned friends proceed, Lord, may I just point out, Lord, I was appearing, there's no doubt, but Lord, today I looked into the papers of both the writ petitions. Lord, the challenges are, Lord, different provisions of the Kolkata Municipal Corporation Act. In Sahujan matter, the corporation has not filed, Lord, an affidavit because the virus of a provision is under challenge. Mr. Banerjee has challenged a separate writ petition, has challenged a separate provision. But insofar as Mr. Majumdar is concerned, his challenge is of a different section, virus of a different section. So, Lord, I feel that, Lord, the corporation should, Calcutta Municipal Corporation should file an affidavit to his application, Sahujan matter. Because
Otherwise, my lord, I am ready.
Lord, because your lordship directed to prepare a written submission. Lord, while looking into the written submissions, Lord, I found that, Lord, the
pleadings
challenges are different. So, Lord, I need to file an affidavit insofar as Sahujan matter is concerned.
Okay.
The other matter, Lord, Indian city properties, I am ready with the notes also. I'll just hand up.
No, only one submission, my lord, subject to whatever your lordship would decide. My lord, both the provisions had been introduced by the same amendment act subject to correction by Mr. Banerjee and Mr. Kaur. And these are validating provisions, again subject to correction by Mr. Banerjee. My lord, so my lord, if compartmentalized hearing is taken.
No, we'll do it together only.
Together. Very good.
We'll do it together.
Yes.
Maybe we'll push it by Mr. Carr 2 weeks.
For them, my lord.
Yes, but Lord, the other matter can proceed. There is no difficulty.
My lord,
See,
then I will miss the bus, my lord. I may miss the bus.
He has a submission, which I also find bit reasonable, to the extent that the amendments which have been carried out
Are by a single amending act.
by
So-
single amendment. So if that is the issue, then let us have
One is
both.
2019. Yes, kindly give me 1 minute. One is 2019. The other is 232B. This is not by the same amendment. One is by the 2022 amendment. The other is by the 2019.
Then it's different. Then I'm sorry.
Then we can start.
Then they can start, my lord. I can come back.
But so far as the Sahujan property is concerned, kindly give a direction, Lord, for filing of affidavits by 2 weeks.
Take down. Learned counsel for the respondent, Calcutta Municipal Corporation. Seeks and is granted 2 weeks.
Yes.
To file his affidavit in opposition.
Opposition.
Affidavit in opposition. Reply to the same, if any, within 1 week.
1 week. 1 week for.
Within 1 week thereafter. List after.
Well, kindly give us a date, my lord.
4 weeks. I'm giving a date.
Kindly give us a date.
List after 4 weeks. देखो 4 weeks क्या होता है? Hey, 4 weeks देखो.
After
क्या
4
होगा?
weeks. I'll.
What will be the date?
Yes, Lord. We are on 10th of July today.
4 weeks will take us to 8th of
7th
August.
of August.
7th of August, my lord.
7th, which is Thursday.
But till now, my lord, since the matter is pending, the corporation has not taken any coercive measures so far as my matter is concerned.
They are not taking it. It's a short date.
In fact, I had suggested that, Lord, if they want, Lord, we can give them a hearing and.
No, my lord, let us
Being heard.
They didn't.
Well, let us.
Being the astute goal scorer he is, the moment there's a chance to go to the penalty box and shoot a goal, my learned senior friend will not miss that
The
opportunity.
ultimate terminal.
That be the game.
And now,
Rules also permits, Lord, fouls.
Yeah, that's true.
This is wonderful.
Lord, I just wanted to say this, that, Lord, there is a huge amount of tax outstanding.
We will try to finish it.
Yes.
We are not shying away from.
For just 3-year period, there can't be, Lord, any.
I'm keen on finishing it.
Yes. Only one
I'm ready
submission, my
to
lord.
hear it, finish it.
The number of copies such an act.
Very good. Lord, 4 weeks.
If need be, we can keep after 2 o'clock on any other day too. Not only on Thursday.
Yes, we can continue because
we can give 2-3 dates and
finish it off.
and
But Lord, both the matters, I think, which should be heard, Lord, independently, because there,
Only
there
one
two-
submission, my lord.
Up to you.
Subject to, my lord, whatever Mr. Banerjee.
You
would
want
say.
both the matters to be heard independently, we
Yes,
can have.
I was suggesting both be heard successively. I'm sorry.
Up to you, you tell me what you.
Lord, I would be comfortable if, Lord, they are heard, Lord, independently, because, Lord, the
But always think about me also.
But if judgment, one
provided,
judgment.
Lord, there are no overlapping, Lord, situation, because the
I leave it to your wisdom, Mr. Carr, but you must think it from the perspective of court, this court also.
No, absolutely, because, Lord, I don't want to argue and re-argue. Lord,
Because
a
if I can club it and I can pass a order,
Yes,
I think
yes.
that will be,
because
that
that
will
will
be
be best,
best.
That will be best.
Because, Lord, the amendment will have to be considered by your lordship separately. There's no doubt about it.
fine, but then the
Provision is same, the crux is same. How much can you go
argument
back?
will not differ that much.
Yes,
Yes, yes.
একই হবে, argument তো একই
To my understanding, I mean, I can be wrong. I'm not saying
But,
that.
if I have to, Lord, meet a two-prong attack, Lord, I would much rather, Lord, accept, Lord, one at a time. So that's why I'm saying that if you're
But it should not be a problem for this court. Also keep that in.
no, shouldn't be. I'll ensure that. I'll ensure
May I make a humble
Hey,
submission?
it can be taken up successively. I mean, but I
Yeah.
was thinking that if I could argue it, Lord, one at a time.
May I make a very humble submission here, my lord? The crux of the provisions which Sahu Jain and ICPL are challenging is retrospective assessment being made under the ARV system, which according to us is an unconstitutional provision. Now, they may have come in by different amendments. 2019 amendment for his 179 2D, and as far as I am concerned, is the 2022 amendment 232B.
No, I am
Result is quite the same because
mine is 2022.
no, she's saying it's a 29.
No, it's 2022.
2022 23 amendment, same amendment
Same
act,
amendment act.
different provisions. I think we should hear it together.
Yes, my lord. It's same.
It will save Mr. Kaur also a lot of
Kindly
time
give
and energy.
Now, kindly give me 1 minute. Please ensure that it is by the same
If
amendment.
it's by the same amendment,
179 2D,
Act
second
on
proviso.
act on.
Kindly give me 1 minute. Lord.
Just 1 minute.
2D, second proviso.
আমাদের একটা ভাষা জানি
2009.
I have discharged my board.
Yes, I am ready, my lord.
I am also ready.
We are all ready.
170. No, for him, I need to file an
Yes,
affidavit.
you've already-
Without that, Lord, I can't take a chance.
Absolutely.
What? Because later,
Yes, my lord.
Lord,
232B was also introduced by the same amendment act.
Then we'll have it, Mr. Carr, we will have it on.
232B, 230
Both them.
232B is 2022.
And this is also 2022.
No, 2019.
Which one? No, we are challenging 2022 amendment act.
So far as your 232B is concerned, it is
I am
2020.
not challenging 232B. I am challenging 179 2D. Of the
Then it's
20
fine.
My lord,
Then we will have it too.
It will all come
No,
down.
he is challenging 232B. That's what I'm saying, Mr.
No, he-
Banerjee.
I
What
am
Mr.
challenging.
Mojumdar?
May I just indicate? I am challenging section 179 2D, which was amended
By the same
by
notification,
the same amendment act.
same
No.
amendment.
2019 amendment is his challenge.
No. Jadimda, perhaps
That is
incorrectly instructed. That's not so. My specific
very well.
challenge is
I
the
don't want to
2022
disturb your
amendment
lordship,
act.
Lord. I was given a wrong impression. We'll come back and re-argue this matter.
Then we'll have it on the 7th. Both the matters.
Yes. 7th August.
In fact, my lord, my first read.
Lordship, we could have started today. I mean, but I'll leave it entirely to your lordship. I'll leave it entirely to your lordship.
You want to start, you can start.
I mean,
I have
But my lord,
3
without the
o'clock, I have a
pleading-
division bench.
for me, my lord, I will not be able to start because
Let's not start.
fair enough. And then again, linking it will be.
yes.
No,
Fair. No,
not
no,
very convenient for me,
no. Whatever. Courts convenience should be paramount.
because then I'll,
And then go back.
when you're in a flow, you can just finish.
Yes, sure.
Yes.
But would your lordship in that case think of keeping a 1 or 2 consecutive
will.
dates?
We will.
So that the,
We will try to finish it off,
So that we
because
can
we
finish
will
it
not give that 1 week, 1 week. will
yes,
not.
yes. A few consecutive dates.
Mr. Carr, we will try to finish it off. If we start on the 7th, then we'll have it 7th, 8th,
Yes.
Yes.
all right? And maybe on 11th, 12th after 2.
Yes.
7th, 8th, 11th, 12th. Grateful.
My lord,
We can arrange
this
our affairs
direction for affidavit be given also.
Let that come, we will indicate
The
this on
state may
7th,
also
but
file
this is
affidavit in
what
the meantime.
I am of the view that we'll have it Straight
Very well. State council is present.
and finish it off.
State council is present.
Well, if the state wants to file an affidavit, let them file, because on the returnable date,
Madam,
they will prefer adjournment than.
Madam, if you are for the state, do you want to file? I'll close your right. If you want to file something, file it. Otherwise, I'll note it down that you don't want to file it.
I am in,
350?
Item number.
That there is a pleading which is.
He's in item number 2.
Is
In item number 2, mine.
you want to file something? Until date, what were you doing?
আমাদের কি other side?
Lord, in item number 2.
Well, what we can do.
Why you have not sought this liberty from the court? You have never indicated you want to file something.
already we have prepared my
What prepared? You have prepared a
I have just given it over.
She's prepared a draft opposition. She's given it for vetting.
2022 বলছে কি করে হবে?
then I'll give it.
22.
But then there be direction in both the matters. For
You are appearing in the other matter also?
No, I don't only three.
Who's appearing in the other matter for the state?
Mr. Satyajit Talukdar had appeared, subject to. ঠিক তো? It's correct.
He's not here.
Well, your lordship passes the order, we will communicate, indicate that in the order.
Just take down. In WPO 362 of 2024, learned counsel for the state, Miss so and so, seeks and is granted 2 weeks time to file her affidavit in opposition. Reply to the same, if any, within 1 week. Same date, 7th. And in the other writ petition,
Lord,
none appears for the state. Though the state is permitted to file their affidavit in opposition within a period of 2 weeks. Reply to the same within 1 week thereafter, list on 7th. Though none appears for the state, or should I mark his appearance and then
kindly mark his appearance.
Kindly mark his appearance.
Mark his appearance.
Well, it is appearing in the last order that Mr. Talukdar appeared for the.
But Talukdar এসেছে তো, অসুস্থ হয়ে পড়ে
Well, if Mr.
My name has not been incorporated. I was present by that date, my lord. My name has not been given. That's why I am carrying this.
which order, madam? 26 June order.
Yes, my lord. Although I applied my name.
Correction kar do. An inadvertent error has crept into the order dated 26th of June 2025, wherein name of Miss so and so appearing for the state has been inadvertently missed out. Let her name be corrected.
Mr. Talukdar.
Mr. Talukdar.
Mr.
Talukdar is.
Sujit Talukdar was led by the learned advocate.
Advocate.
That's the noting here. If Mr. Talukdar has come here either physically or through web, then if he's come to court,
Your lordship can. Whatever.
Anyway, none for the state.
None for the state.
None for the state.
We will communicate.
Though the state is granted the liberty to file an affidavit in opposition within a period of 2 weeks, reply to the same, if any, within 1 week thereafter, list on 7th.
Grateful, madam.
But
I've already made the correction also in the earlier order, madam.
Lord, in the Indian city property,
Yes.
there is a pleading which is to be filed. We were supposed to file an exception to the supplementary affidavit. Maybe file this.
362. Exception to the supplementary affidavit is taken on record. Filed by the respondent, KMC is taken. We'll have it at 2 p.m. only on the.
Yes, madam.
If it's so commends your lordship, Lord, would your lordship, Lord, also, Lord, mention the schedule which we propose?
We will do it on 7th.
7th.
Subject to
Yes, yes.
completion of the pleading. That's why I'm not indicating.
Yes.
We filed, Lord, the notes.
If you can, or you can come after.
I think
you can,
we'll place it on the 7th and file it.
Yes,
after finishing
Take
the
your lordship
argument
through
also.
the note and then.
You can do that. But this is interesting to note that amendments are challenged before a single bench.
Yes. Here it's done.
It doesn't go to.
It doesn't go to
Here
the
it's
division
done.
bench.
Here it's done.
Of course,
There was a provision, my lord.
there matters, Mr. Carr. DB, division bench,
Division bench.
as well as any amendment, division bench.
But this practice
a
was
practice
introduced
for-
for
No, this is good in a way.
this good in a way.
Because the litigant gets, Lord,
Exactly.
Two fora.
In a way, it's good.
It's because you
You get two.
you can an LPA and then
But my lord, this was there for a brief period of 7 or 8 months. That practice was introduced that for challenging the validity of any provision, one has to move the division bench. That noting was, my lord, deleted later on.
Okay.
That was rather mistake. Which text?
That was rather not one.
Yes. The spelling, no? Mr. Joydeep Kaur, Joydeep Kaur, learned senior counsel for the KMC, seeks and is granted 2 weeks time to file his affidavit in opposition. Reply to the same if any within 1 week thereafter. List on the 7th. All right. Any other confusion? You clarify. Okay. Anything else?
the time for completion of pleadings be mandatory and peremptory.
Yes,
Otherwise,
yes.
there will be again a
That much I will expect from all of you.
Yes, my lord.
For that, you don't need it. And all of you are appearing, Mr. Madhukar, Mr.
This has come,
Banerjee.
I know why it has come. This has come because his pleadings are complete now.
This is Mr. Kaur will never miss a chance.
For another matter.
Even if it's outside the penalty box, he will have his shot. That was a through pass. He saw immediately he saw money and he started saying, "But we can give you a hearing." And we said, "No, nothing." Second time, it's outside the penalty box, but he's just.
All right. Then I'll come at 3 o'clock for the division bench. The board was discharged.
Yes, I was battle ready, so to say.
Yes. Our understanding of original side is very different in Delhi High Court.
Yes.
Here it is territory.
Territory.
Yes.
Their business.
The business.
Business.
Thank you.
Like,
আমি কি বলেছি মুখ খুলেছি একটাই ম্যাটার তো এই তিনটে 1 2 3 আরো আছে তারপরে অন্য in this matter in these matters I am for the applicant lead petitioner appellant and applicant
Yes.
in the contempt application.
Yes.
Lord, in first application
Yes.
there is one application for substitution being CAN 8937 of 2014. This was been made within time by the heirs of the deceased freedom fighter. Well, I have made all the I have made the widow party here. এটাকে substitution.
Sir, why are these matters?
Before your lordship goes to this matter, fourth must order, my lord, last that your lordship kindly peruse justice Jamallo Bakchi, my lord, honorable justice, as your lordship then was, my lord, your lordship kindly peruse that order. Subject to God. Though the brief is not with me, my lord, just now it has been. Fourth March 2025. The direction of your lordship's court, my lord, to arrange the, my lord,
For reconstruction of the brief.
reconstruction and
Reconstruction has been effected, has been made.
and my lord to place the order sheet with regard to, my lord, subject to correction, my lord.
Let this matter go before the roster bench. The only direction which was given by us was for reconstruction of the file.
It has already been made.
It has been done. Report has come from the IT department. It has stated that there are 2 orders which are on record. Those orders are there. So what else? Let it before the roster bench. Why has it come here?
Matter. The substitution is
the matter.
Regular bench has
Before your lordship.
My lord asked me
Since
the
my
one
lord is a-
question. Why these matters are before my lord?
Yes.
My lord, in fact, a writ court was moved. But in the what happened in the case, my lord, I kindly allow me 2 minutes time. The husband was getting the pension under freedom fighters pension scheme. Well, on an complaint that was stopped. He has not given any hearing. That was anonymously not many. That was stopped without hearing me. Then when the writ application was moved, the writ court set aside the order of cancellation. And thereafter, my lord, we prefer an appeal because there was no direction for resume of the payment. In the appeal court held that as the order impugned has already been set aside by the trial court, so go on paying the pension.
There is another order that is 18th of 14th of May.
আছে তো এখানে
তারপরে এখানে এসছে করার পরে
Just keep your.
My lord, as the appeal court order not complied with, we filed an application for contempt. My lord, as subsequently long the matter was pending, it could not be heard. The bench which was heard, my lord, that was presided by the then Chief Justice and my lord Justice, my lord Bagchi. My lord, as the Chief Justice gone, matter was assigned by my lord Justice Bagchi and you heard by my lord and with my lord Justice Bagchi. Because as in the meantime, Justice Bagchi has elevated to the Supreme Court, I had to make an application for assignment of then the matter was appeared before my lord Justice Bosak. My lord Justice Bosak released as my lord is in this court, so matter should be heard by my lord. Then I made an application before the Chief Justice for assignment of the matter. And on the basis of that application, the matter has been assigned before my lords.
See, I, along with Justice Bagchi, has only passed one order, which is 4th of March order.
Yes, Lord.
For reconstruction of the file.
Yes, Lord.
Right?
Yes, Lord.
And compliance was supposed to be filed as far as reconstruction is concerned. That has been done.
Yes.
It is there.
Yes.
Then subsequently, no effective orders have been passed by my bench.
Yes, sir.
So why the matter has been assigned to me?
It is up to my lord Chief
Kindly
Justice.
peruse why the matter has been assigned, my lord. Your lordship kindly peruse, my lord, the order dated 14th May 2025. 14th May.
Since one of the judges were there,
We have no objection if your lordship's court hears the matter, my lord. We have.
14 May কোথায় সেটা হলো কেন?
আছে আছে দিচ্ছি দিচ্ছি আপনারটাই বলছি ঠিকই তো বলেছেন
ঠিক আছে, কোনো অসুবিধা নেই। যেখানে আমার হিয়ারিং হয়
Therefore, my lord, and pending hearing, there are some of diet, and they are filed, my lord, they are supposed to file an application for substitution.
they have filed.
In that used to be allowed and the memo of appeal to be rectified, and thereafter your lordship can hear out the matter. But the substitution application should be allowed by your lordship, my lord.
Yes, yes, my lord. I am paying that source.
We don't mind, my lord, we want, my lord, your lordship hear the matter. And if there is anything, my lord, to comply with, the authority will comply with, my lord, subject to, my lord, other formalities are complied with. তাই তো বলছি, ঠিক বলছি।
জোসেফ দেখছি দাঁড়া।
বাকি কি মরে গেছে আর ক্যানের নাম্বার গুলো দাও।
দিয়েছি জোসেফ, দিচ্ছি, একটা তো ধরেছি, ক্যান বলেছি তো। জোসেফ দেখছেন তো? আরে বলছি দাঁড়াও, আউটকামটা
রেগুলার করো, রেগুলারাইজ করো।
89 হ্যাঁ
8937
সাবস্টিটিউশনের ক্যান
জোসেফ কি আলোচনা করছে দাঁড়া। লিস্ট দেন না, পরে পরে কোনটা আছে দেখে নি। একটা লিস্ট দেন না, ওইটা এক্সট্রা আছে তবু এক্ষুনি
ক্যান পেন্ডিং থাকলে তো
আরে
দিতে হবে।
কোনটা কোনটার পরে কোনটা সেটা বলবো তো, নাম্বারটা বলবো। এই যে নামগুলো বলবেন, তা নিয়ে বলবেন।
এইটায় এইটা রয়েছে,
হ্যাঁ
ঠিক আছে,
ননিগোপাল।
এইটায় 1
আচ্ছা, হ্যাঁ এইটা লিখে নেন, ননিগোপালটা 2, ননিগোপালটা 2 লিখে রাখে মাথায়। আচ্ছা, একটা লিখে রাখ ননিবালা।
এইটার সাথে এইটা গেল ইফএমএল গুলো আমার
আরে 3টে এফএমএ দেওয়া আছে, তাতে কি আছে, ক্যান আছে, এইটা
এই যে এই আরেকটা এইটা 3
ঠিক আছে তো, ঠিক আছে। তো নোটিফিকেশন তোর কাছে তো এসছে তো, 3টেতে ক্যান আছে। ঠিক আছে, জানো রে বাবা, শুনে নিয়েছি তো। সেকেন্ডটা দুটো কেন আলাদা করে রাখ।
Yes.
So in the past
humble
matter,
submission, my lord,
in the
CAN
past
should be
matter,
regularized fast, my lord. This
Yes.
was
Substitution being carried out?
no, not yet pending before your lordship. I do not know.
substitution application has not yet been allowed. So in past matter, your lordship kindly take CAN 8937 of 2014. This is in time. There is no delay. একটু দেখে নেন।
একটাই কপি আছে, একটাই কপি আছে কেন?
একটা দুটো কপি করে থাকবে তো।
সবুজ কাগজ।
Well, I am the wife who is entitled to have the freedom fighters pension on the death of my husband.
She has to apply a fresh.
No, anyhow,
What wife has to apply.
what is to be done, that is the another question, merit of the case.
This is
This is a contempt application.
everything.
This is not read application.
She has to, after the death,
Whatever is there.
that is the scheme.
No, no, I am not. ঠিক আছে ওর মেরিট হোক যশের শুনুক না
একটা নাকি সাবস্টিটিউশন না তিনটে?
প্রথমটা একটা
একটাই
it is ননী গোপাল এই যে ননী গোপাল কোথায় ননী গোপাল একটাই
বলছো
ক্যান 8937
and 8937 order child and 8937
কানাই মারা যাওয়ার জন্যই তো সাবস্টিটিউশন
কানাই হচ্ছে না এখন।
কানাই নাকি এটা ননী গোপাল হচ্ছে তো
today we have got no brief my lord because at 3:15 it has been assigned
3:15 has been to you.
At 2 p.m. we got, upon taking information, we come to know that the matter has been, will be taken by my lord today. I can supply the copy.
Mr. Manna,
Yes,
bereft of the fact that we'll let you come back on another day since both of you are handicapped, but I just wanted to know if you see the order of order complained of 29th August 2013. The only direction seems to
page
be
57.
Only direction seems to be that the authorities were to conclude the hearing and pass a fresh order. Has that not been done, madam?
কনক্লুশনটা হয়েছে কি এইখানটা পড়ো না এই টেনশন চালু করার জন্য it is decided এই জায়গা page 58
I would like to think it's the first matter since the brief
Can I
has been
assist,
had.
my lord? Can I assist? Will your lordship kindly come to the last paragraph of page 58?
Yes, tell us.
It has been decided to stop pension to the present freedom fighters who were receiving the pension on the basis of the adverse material being received from the state government, and ultimately the sanction order of such pension has been revoked. As such, the learned single judge was of the opinion that the fresh order was required to be passed. After hearing the writ petitioner, we find no ground to interfere with the such and such. Then, my lord, however, as the learned single judge has ordered to keep the order of revocation of sanction of pension in abeyance, obviously the consequence to keep the same in abeyance have to be followed, meaning thereby the freedom fighters' pension shall be continued till fresh order is passed. Till date, no fresh order has been passed. So far, as per the division bench order,
No,
the
Mr.
pension
Manna,
is
Mr.
required
Manna.
to be-
Fresh order to be passed only in the event the pensioner was alive. Once the pensioner has passed away, the wife or the person entitled will have to make a fresh application under the scheme.
My lord, it is.
This is just a prima facie.
When my husband has been died, till that date, pension was to be paid. After that,
till he was alive.
Still he is alive. That is the area of pension called. And after that, I am to inform that I am entitled to have the pension. Then the fresh PPO will be issued in my favor.
and thereafter the procedure changes my lord within certain time within 6 months from the date they have to be-
Perhaps
they have
my
to be-
understanding is not up to date. That time has already been extended for 4 years. In 24.
Don't worry, we are also not up to date. We are also
My lord, I am not indicating. My lord, I cannot.
This is the case of
My learned friends.
2024
Why I am saying
guidelines.
it is
When
his
the
document.
application was
We
made,
got to
then
procure
2024
from
guidelines
him.
were not there.
We have procured from him. So it is within his knowledge. That
you want to come back.
Yes, my lord.
When do you want to come back?
কবে আসবে কবে নেক্সট ডেট কবে রাখতে চাইছেন
As your lordship will. 7 except my lord 22nd to 25th. হচ্ছে রে বাবা।
Correct, correct.
Now, whether I will get or not, that's another question. Now, the contempt application is to be disposed of, either in my favor or against me. Until and unless that is done, I cannot proceed. And they may not also be able to proceed.
But before that,
So, your lordship kindly allow the CAN application
is
and
to be
fix the contempt application on any day, your lordship.
Manna, you are wrong. To that extent, that contempt, we will keep it pending. Let them file a compliance report. What exactly is the?
Yes, sir. That may be done. That may be done.
For the previous order is concerned.
Yes.
So for the previous order,
Yes.
Before that, I submit before, your lordship, if substitution application is pending, my lord, this is irregular, my lord. The appeal cannot be taken
Yes.
up for hearing.
That will be clear. That will make clear difficulties because
Firstly,
because
I mean,
because if
Substitution application is only in one matter.
in second and third also,
All three matters.
all three matters are substitution is there. Unless substitution is allowed, let us assume they allowed to intend to pay the arrears. Unless I be on record to whom they will pay.
We have not looked into the, and we are top about, we are led by London Additional Solicitor General, he is also not.
At the request of the London Council of the parties, let this matter be listed on, give a date.
Save and accept 22nd to 25th. Save and accept 22nd to 25th. No, I will not be available in Calcutta.
21st.
21st.
He said 22nd to 21st.
21st মানে কি?
21 জুলাই
কি হয়েছে? No problem. 21 জুলাই কি প্রবলেম আছে? কি প্রবলেম আছে? কিসের মিছিল আছে? আসতে পারবো না। জজ সাহেবরা আসবে আমরা। No, I will come. No problem. I will come.
No, we won't deny your.
History says, even wearing the half pant, I have come to High Court during the flag.
Please, not anymore.
And we are here full pant. Change our dress here.
29.
I am to come for my client.
29.
At your lordship.
Mr. Manna, have you annexed the PPO containing the name of the petitioner? PPO, pension payment order, initial pension payment order.
Yes, what happened?
ঠিক আছে, next thing we will.
PPO একটা ইস্যু করেছিল না?
কাকে? তার হাজবেন্ডকে দিয়েছিল।
একটা হাজবেন্ডের PPO এর মধ্যে বউয়ের নাম থাকবে না?
29th.
29th.
My lord has not disposed of any application today. Only fixed the matter on 29th.
I pass some order, my lord, so that we can.
Pass an order, you are taking time.
Unless order pass, we will not get the.
If you clear the bills.
So for their sake, let an order be recorded. What are
29. 29.
ওই 29 তারিখে আরেকটা কি ফিক্স করলো না 30 তারিখে আরে এর ঘরে নারায়ণ ঠিক আছে ঠিক আছে in second and third same order may be passed.
Yes, all three matters same order.
চলে গেলেন তো চলে গেলেন সে তো ছিল এখানে They thought similar order has been passed in three.
Gave their appearances.
But they were present.
Yes, gave their appearance.
You are appearing in all three, right? All three.
All three matters.
Well, we have given the slip, my lord.
You just want to make sure that you are appearing in all the three matters.
Yes. One, two, three, four. Eventually, less competition possible. For the party interest on
Same date. None for the parties listed on print. Five, six. Five, seven. Subject to the order of the let the matter be placed before another bench of which last one order same broker.
আগের দিনে যেটা রিলিজ হয়েছিল সাহেবের নাম সেম
Since the roster is
সেম এই দীপেশ ব্যানার্জি ছিল
on the list. Just give the order.
এই তো আছে তো